Good morning, and we will have a presentation up on the screen in just a second. I'd like to welcome everybody to our event. This is the first time we're doing this live. If you have any questions, feel free to use the chat box and either myself or somebody in the studio will answer you. We want to start out a couple quick housekeeping details about today. As over the last 33 years, the information we're presenting is both practical and implementable. But a few quick housekeeping details, and then we're going to jump right into our market and the legislative update before bringing up our other speakers. You will be able to get all of the materials from the website, and we will send another email with that. You should have already received an email on how to download materials post-event. As always, you can reach out to me and we'll connect you with any of our speakers. As well, anyone who provided their Ohio, Florida, Illinois, or New York registration numbers will receive CLE credits. We're also offering up to 8 hours of CPE credits if you're a CPA. Just email that information to Kelly if you've not already done so, or feel free to call Kelly at 440-974-0808. After the event, we'll be sending out a quick survey. We ask that you complete that. That's also what we use to document your attendance to the various state Supreme Courts, so it's important that you return that. That'll be sent after tomorrow, which is the second day of the event. And then you will receive a hard copy certificate of completion that you can use to prove attendance within a couple weeks afterwards. Please note that if you're attending tomorrow, there's a separate login and password. If you need any help with that, again, just email Kelly and then we can take care of it. So, as always, over the last 33 years, and it's hard to believe we're saying that because a lot has certainly changed over that time. We're going to start out kind of discussing the political, economic, and legislative landscape, as that's going to really drive what happens in the coming year. As we progress today, both with myself and our various speakers, feel free to text questions. We'll generally answer them towards the end of the sessions or get back to you. As I'm speaking, I am seeing some of the questions, but it may be a little bit disconnected, so we apologize for that. Really, three key issues this year. One, what happens with the election? I think it's fairly certain that we know the outcome on the presidential election. However, stranger things have happened. With that being said, a key right now is going to be the Senate race that we're seeing. And the Georgia race really is going to determine more than just the outcome for the Senate, but it'll also determine what happens with the political appointments. And as I say, that's going to be decided on January 5th. That has some very big implications that we're going to touch base on in a minute. We also want to look at tax policy that'll impact both you and your clients as a business and as individuals. The tax policy, again, will be largely dependent on the outcome of that Senate race. And then we want to talk about COVID, potential shutdowns, which will have an impact on the economy. It's not so much what happens with COVID itself, it's what the response is nationally. Now, it's interesting because every year there are reasons for people not to invest. And I think at the beginning of the year, the things people are concerned about are not the things that end up being a real risk. For example, when we had this meeting last year, the big concerns were North Korea, the tariffs and trade war with China and other countries, and the breakup and Brexit in Europe. I don't think anybody's concerned about those things, as really the focus became COVID and then our election. If we look back over time, there's really about hundreds of reasons, but 83 large reasons that people should not have invested. I do understand that people are getting some sound issues, and we'll look at that. By the way, we're working on that. If anybody's having kind of reverb or echo, so we're working on that. And we will, by the way, record this. So if something's missed, we can go back, or you can go back and listen. It's interesting, though, if you go through the years, and these really line up with a lot of the CLE events that we've done. More recently, the Great Recession / Depression due to subprime, 2008, huge unemployment, 2009, when the U.S. credit rating was downgraded, 2011, the war in Afghanistan, et cetera, et cetera, et cetera. But, things continue to progress. And ultimately, while you've got dozens of reasons not to invest, you can see that since 1934, what the growth has been. And ultimately, the markets always go up over time. And well-managed portfolios should be able to make money in almost any environment. Now, one of the biggest questions we get is what the impact of the election is going to be. And it's kind of interesting because if you look, typically when a Democrat is elected to the White House, the markets have actually done better than with a Republican, which is a little bit counterintuitive. So over all of the election years, in the year following, the markets have returned about 5.7%, whereas with a Republican, they're flat to slightly down. It's important to note that what your investments do, what your investments for your clients do, really should not be dependent on the markets. While you'll generally move in the same direction, the portfolio can certainly outperform or return funds even when there's extreme volatility. But typically when a Democrat's elected, the average following year return has been about 11.7%, whereas when a Republican's elected, it's basically zero. Obviously, these are long-term averages. This is since 1927. And so, individual years may be different. When a Democrat is elected after a Republican, though it's interesting to note, that has been historically the best returns. The other thing that helps is when you have a split government where you have one party in the White House and one party in the House or the Senate. The best scenario historically being Democrat in the White House, Republican Congress. So again, what happens with the Georgia runoff race, which ultimately is going to be the most expensive Senate race ever, will determine where we stand, as far as the government goes. And with the Senate in Republican hands, that will mean a lot of political appointments may get blocked, as will policy. If the Democrats sweep all three, it's likely things will flow through a little more. However, it's important to keep in mind that there is a little bit of a damper on what potentially could happen because we have another election in 2022 for the entire Congress. And I think one of the things that came out of this election is people do not like socialism or radical policy. Ultimately, the Democrats lost seats in this election, regardless of how you think the numbers were counted. They lost state legislatures. So I think politically there's some concern. But just from a practical standpoint, regardless of what you like, that they're reconsidering policy, and that's going to dictate a little bit how radical they go. Now, it's important to keep in mind, and we've talked about this for 30 years, but it's more relevant today than ever before, that the role of the media is not to inform, but it's to sell advertising. Never has the media, particularly cable opinion shows, been more polarized than it is today. And the fact is, you have millions of websites, over 1,700 commercial TV stations, thousands of magazines and newspapers, and any pretense of being unbiased is pretty much gone as you pick your media outlet. Although it's interesting that more people today receive their media via social than from cable TV or television. And so with what's been happening with particularly Facebook and Twitter, I think you're going to see more regulation, but you're also seeing more of a bias that's been happening that I think has influenced a lot. And that, in the coming year, may be one of the biggest issues is the regulation of social media as media versus simply social platforms. If you look at 2019, terrible headlines. Dow plummets 800 points. You have the recession fears. If we go back even to April of this year, the headlines were terrible. As it looked like things were going to collapse. The markets have moved up over 30% since then. So again, if people are making decisions based on the headlines, they are missing out on what's really happening. And as we've talked about for 3 decades, it's important to look beyond the media, look at the facts, take a much longer term view than the next news cycle. In fact, nobody, I think, would have guessed that November of this year would be the best November since 1987. Huge, huge year. Harvard did a study of Trump's first 100 days, and essentially 80% of the broader media was negative, and more than 90% of some channels, particularly NBC, CNN, and CBS, was negative. What happens after this coming inauguration, who knows? But clearly, even in Europe, it's interesting that by far media is negative. And quite frankly, we're seeing that because people like negative news. Nobody wants to hear about 10,000 airplanes landing safely tomorrow. They want to hear about the one crash that happens. And we're just driven to that as far as that goes. It's interesting that, again, we hear about volatility, and I would expect in the next couple months to see quite a bit of volatility, possibly a correction of as much as 10 or 15%. That's normal. In fact, we have a 5% correction about every 2 months historically, and a 10% correction every year. 10% today would be 3,000 points on the Dow. If the Dow dropped 3,000 points next week, I think the media would make it sound like the world's ending. The fact is, that's a normal occurrence. A 6,000 point drop is something we see about every 30 months, 20%. So, as we said, a properly managed portfolio should not be dependent on the market or overly concentrated. But market volatility is a norm that we're going to see. Over time, the other thing is during the year, it's normal to see a large drop. And then at the end of the year, when the whole thing is over, someone like this year, we had almost a 30% drop March, April, and today we're up. Ultimately, we'll see where we're at in a couple weeks. But the orange lines show the intra-year drop, whereas the blue shows where we ended up. And if somebody would like, we're happy to email you a copy of this chart to keep and look at. This is updated every month, and certainly it can be easier to see when on its own. This is a critical statistic. 96% of market gains come at 0.9% of the days. If we look at 1963 through 2004, there were 135 days that most of the money was made out of 14,800 days. It is impossible to time markets. And the worst thing people can do is to get out. If a portfolio is properly allocated, you can take advantage of the volatility to rebalance. Panicking or getting out and waiting for it to get better costs tremendous amounts of money. It's why over time, investors as a whole tend to lag the performance of the markets or even the mutual funds that they are in, because they tend to get out when things go down and get up when they go up. The reality is that we cannot time the markets. I've done this for 30 years. We've won all kinds of awards from everyone from Barron's to Forbes. We don't know what's going to happen tomorrow. I can tell you what we think is going to happen longer term, but day to day, week to week, it's impossible. And again, this November showed, how unexpectedly things can go well as opposed to wrong. But again, 0.9% of the days. So essentially, it's less than 1 day a year that you've got to be right. If people get out, what happens is the returns dramatically drop. And so if we go back and we look at a 20-year period from 2000 to 2019, if you'd invested $100,000 in the market, you just let it sit, which is not what we recommend. Your $100,000 grew to $324,000. If you miss just the 5 best days, so 5 days out of 20 years, your returns are $214,000. At least you made some money. If you miss the best day each year, on average, you basically made nothing. You were flat as far as what's happening. So after 20 years, you made nothing. And then even worse, if you missed just the best 25 days. So for 20 years, 25 days you were out. You actually lost money after 2 decades. And that's exactly what happens. People get out and they think they're going to wait for things to get better. And the problem is, if things go down further, people don't get back in because they're still bad. If they go up, people wait for them to go back to where they were, and ultimately, they don't get back in. After a year or so, they're tired of hearing their friends making money. And so what they do is they get in high. They get out low, they get in high. The key is to stay invested with the proper allocation. It's not buy and hold. It is rebalancing as makes sense for your situation, not because of what the markets are doing or because of an emotional decision. And that's something that a trusted advisor can add tremendous value, not because they're helping pick investments, but they're helping you make good decisions, taking the emotion out of it. It's the same reason, lawyers are told, do not represent yourself in a case, or doctors are not their own physicians. They have a doctor. Even somebody that has the capacity and the knowledge to manage their own funds probably should not do so. Now, why are we optimistic? Markets are high. We have a global pandemic, all kinds of confusion with the markets. One of the biggest things is technology. Think back to the 90s. Look at the pictures here. And that is not me, by the way. Think back to what's happened just in the last 30 years. The internet was created. Smartphones, social media, all of these things are happening. Look at what we're doing today, talking virtually, something that was science fiction just 20 years ago. The fact is that technology is an accelerator of growth, and the pace of change will continue to increase. Never has the pace of change been this fast before, and never won't be this slow again. And that creates all kinds of efficiencies for people. There's a wonderful book called Factfulness that I'd recommend by Hans Rosling. And it looks at why we're wrong about the world and why the things that we're focusing on may distract us from how much things have become much, much better. Consider 16 bad things they're decreasing. Legal slavery. If we go back over time, it's much lower. Oil spills, plane crash, child deaths, etc. The cost of solar panels, the rate of HIV, the number of deaths from disasters. If we look at even war deaths, child mortality, ozone depletion, hunger worldwide, things are getting much, much better. Take, on the other hand, good things. The number of movies, for example. Look at how many people have access to electricity and the internet. If we look at the usage of cell phones, clean water, literacy, all of these things are getting much, much better. And I think, again, it's very easy to lose the forest from the trees as we start listening to the media hype with what's happening. There's a tremendous amount of good things happening. And if people focus on the bad, they're missing one of the best opportunities we've had in our lifetimes. It's kind of like with the market, watching a guy with a yo-yo walk up a hill. If you watch the yo-yo going up and down, you miss the fact that the guy is marching up the hill and making progress. And again, a lot of this is because of the media creating misperceptions. We hear about all the deaths in Chicago, all the violent crime. The crime is exploding because of socialist policies by cities like Seattle. All of that may be true. But the reality is, if we look nationally over bigger periods, violent crime has consistently decreased, despite perhaps a spike near term, and despite what the media would have us believe. So it's not about thinking about what's going to happen. It's about asking the right question. And the right question is not necessarily, what is the market going to do? The right question is, how is what's going to happen going to affect me and my clients? And so if we look at what lies ahead with the new administration in Washington, we want to consider that productivity in the United States, despite this short-term downturn, is at a record high and increasing. The United States is one of the most productive countries in the world per capita. Now, one of the big discussions is, if Biden wins and they hold the Senate, he has said in his first, not 100 days, first 100 hours, they want to repeal the Tax Cuts and Jobs Act that was put in place. What does that mean? Well, if they're to repeal it, we look at tax rates. The fact is, for very low income people, the Tax Cuts and Jobs Act reduced taxes. Are the Democrats going to increase taxes on low income people? I doubt it, but potentially it could happen. The fact is, the bulk of the benefits of the Tax Cuts and Jobs Act actually reduced taxes for low and middle income people and actually increased the tax for higher income people. Now, very high income people did see a cut of a couple percent. But again, a lot of what's being discussed is politics, not reality. The deductions that the Tax Cuts Act put in place doubled the standard deduction for everybody. Again, this predominantly benefited low and middle income people. And the fact that they capped the state and local tax deduction at $10,000 really impacted higher income people. It's very interesting that because most states that have high state tax are Democratic states, especially California, New Jersey, New York. And that one of the exceptions that the Biden administration has said is, well, for that, we want to get rid of the cap. So it's going to be interesting. Again, at the end of the day, we need to look beyond rhetoric and look at policy, actions rather than words. And the Tax Cuts and Jobs Act, for the most part, benefited low and middle income people. And in some ways, they hurt higher income earners. And so we'll have to see what happens as far as that goes. The medical expense deduction was expanded. They repealed some of the miscellaneous things, and charitable deductions were increased. And then for this year, because of the CARES Act that was passed, charitable deductions were increased up to 100% for cash donations. One of the things we'd encourage everybody to do is speak to your CPA about 2020 things that need to be taken care of, whether it's charitable deductions or some business deductions with regard to PPP or the CARES Act, and make sure you're taking advantage of everything that's happening. As with anything, we would recommend working with a CPA, working with a professional, because they do have specialized knowledge and they may be aware of things, even if you're perfectly capable of doing some of this stuff yourself. So the Biden proposal, repeal the Tax Cuts and Jobs Act. Now, what they've said is, we're only going to do this for people making over $400,000. That'll be interesting to see how that works. It does impose a new Social Security tax of 12.4% for anybody making over $400,000. This effectively could raise the top tax rate to beyond 44% if you're making over $400,000. They want to increase the corporate tax rate to 28% from 21%. That's very significant because, again, corporations, drive the economy, especially small business. One of the things that's happened with the COVID shutdowns is large business has not been hurt. But if you look at the small service businesses, the mom and pop restaurants, retail stores, they're being hurt very badly. And if we have continued shutdowns, that's going to impact not just them directly, but a large portion of the employment in the United States is small business. They want to establish a minimum tax on book income. Right now, a lot of companies do not pay any tax on income that's overseas. Apple, General Electric, Facebook, Amazon pay almost no tax. In fact, there are years where they actually get tax credits from the government while paying no tax. They want to put a minimum in tax in place of roughly 10%. And that's again, this guilty tax, which is country by country. They do want to temporarily increase the child tax, dependent credits, and a big one is they want to increase the capital gains tax rate to 39.6% if people make over $1 million. If you think about it, that is a big break on the economy. Capital gains, generating capital, is good for the economy. Currently, somebody that's making over $1 million pays a maximum capital gains rate of 20%. So you're effectively doubling the capital gains rate at 39.6. And then there's another 3+% Medicare tax to be applied. So effectively, people could go from roughly 20 to 23% to 40 to 43%. That's one of the reasons people are looking at generating capital gains before year end this year. Because if it looks like this is going to happen, obviously you don't want to pay double the rate going forward. And I think this is something that could pass. again, if the Democrats take the Senate. Because we don't know the outcome, it does make planning a little trickier. Again, with the capital gains rate, we've talked about the Biden-Harris plan would effectively double the rate. The other big one is not just proposing a raise to the top tax rate on capital gains, it's eliminating the step up in capital gains when people pass away. This is huge. Right now, if somebody dies, all of the assets get stepped up, regardless of the amount, for their beneficiaries. In other words, let's say you paid a $500,000 for something, and now it's worth $5 million. You pass away, and your children or your heirs inherit it. The basis for taxes gets stepped to $5 million. There's no estate tax paid. And now, if they sell the asset, there's nothing. Under the Biden proposal, they would pay tax on everything from $500,000 to $5 million. There'd be tax on $4.5 million. And potentially, that could be 50 or 60%. This really could hurt people that inherit family businesses, people that inherit portfolios. Now, there's two ways this could work. One, it could require heirs to pay tax immediately. This would mean people might ultimately have to sell investments or businesses to pay taxes on those businesses. That, I think, is unlikely, but it'd be horrifically bad. It's kind of the Joe Robbie scenario where the family had to sell the Miami Dolphins to pay the tax on the inheritance. On the other hand, what's more likely if this passes is the capital gains tax would not be due until the beneficiary liquidated the asset. Now that's going to raise less tax for the government, but I do think it's more likely. Again, as it's been said, dead people don't vote, although this election maybe is the exception, who knows. But because of that, a lot of people, a lot of policy focuses on estate tax that most people, including your clients, are not aware of. This is an area that's important both for you personally, but also for your clients as they do planning, keeping in mind that the current estate tax limits are due to expire in 2025 anyway. So what's likely? Some initiatives to encourage manufacturing to continue to the United States. There's talk of a retirement savings credit. So low and middle income people, instead of just getting a deferral for putting into a 401k, would actually get a tax credit for doing so. And then tax credits for infrastructure, which I think there'll be bipartisan support for. Unlikely, a major tax increase. Again, even if the Democrats sweep, there will certainly be a lot of pressure from the far left socialist wing. However, politicians want to get elected, and we've had a mandate that the public just does not have an appetite for paying a lot more tax and bigger government. Major corporate tax increases, I think, are unlikely, but we may see that. And then the Social Security donut hole. The other thing there's been a lot of talk about is a transaction tax, that people have to pay a fee on securities transactions. This would impact low and middle income people via their 401ks. Keep in mind, when you have a 401k plan, you are investing, there are transactions. If you own a mutual fund, there are transactions. The fact is the capital gains rate affects virtually everybody. And so there's a lot of talk about this. Bernie Sanders in particular talked about transaction taxes or the government paying for all this stuff, free education, which is not free, free healthcare, which is not free. But it is something that I don't know how much political appetite there is. but it's something we need to look at. I do think, again, when we talk about some of these minimum book income tax, this guilty tax, or Congress added a 10.5% minimum tax on what they call global intangible low taxed income. So it's basically discourage companies such as Amazon, such as Apple, such as Facebook from keeping most of their money offshore. Because you have a lot of countries where there's effectively a zero tax, and therefore these companies would now have to pay at least 10.5%. They're talking about a lot of green energy incentives. I think that's pretty likely. And then, of course, the estate tax that we're talking about, which could be problematic both from a planning standpoint and a personal standpoint. The estate tax is important to look for, and it's not just looking at the federal, but it's important to be mindful of state death taxes as well. And even with a higher lifetime exclusion amount, which effectively today is about 24 million, it's important to understand, again, at the end of 2025, 2026, the rates will drop back down to where they were a few years ago. It's important to plan for low-cost basis property, because when a property is transferred at death, we want to make sure it gets stepped up. Now, again, part of this Biden-Harris proposal is to eliminate that, and we're going to have to keep an eye on that, because that would be very, very problematic. And it would necessitate going back, looking at all planning, and making sure this is accounted for. This is one of the reasons that we would recommend against irrevocable planning wherever possible. And we understand people sometimes use irrevocable trusts to try to minimize or eliminate federal estate tax. There may be some language that can be used in those trusts that gives some flexibility while maintaining the tax advantage of its status. And we can hook you up with some specialists in this area if anybody has questions, particularly about that. So, 2 questions to ask. Number 1, whenever the markets have dropped, have they always recovered? And number 2, when they've recovered, have they always moved higher? And the answer is yes. Every time the markets have dropped, they've always recovered. And every time they've recovered, they've reached a new high. So the question is, how is it that people don't always make money? And the reason, again, comes back to what we were discussing before. People try to time the markets. They get out when they're going down because they're worried, and then they jump in when they go up because they feel like they're missing out. As Warren Buffett said, the 4 most dangerous words for investors are, this time it's different. Because the reality is, it's never different. The fact is, the events may change a little bit, the circumstances may change, but it's not. And the fact is, we've been talking about the same problems for 50 years. Pandemics. You can go back to the polio crisis at the turn of the century. We could talk about Ebola, AIDS, SARS, H1N1, bird flu, etc. There's always a pandemic. We could talk about the crisis in the Middle East, whether it's Israel and Egypt, or what's happening with Iraq and Iran. There's always a problem in the Middle East. They've been fighting for 3,000 years since it was, Persia and Babylon, which is Iraq and Iran. We can look at concerns about taxes and the government and the stability of the government. These things constantly happen, and they really don't change, nor should they drive decisions for your portfolio. There are really only 3 reasons people should be making adjustments to their portfolios and to their planning. And planning should be a dynamic process, whether it's legal, tax, or financial, because things change. Things change with you, things change with the laws, things change with the economic and legislative climate. So number one reason to make a change is your needs change. You're going to need more income next year. Something unexpected comes up. Number two is as you look at the investments, they're underperforming relative to their peers or the index. And this is very interesting. So for example, you could have two investments. One is up 10% this year, and one is down 10%. And we want to keep the one that's down and liquidate the one that's up, because relative to their peers, the one that's up is underperforming. In other words, let's say we have Fund A that buys large US companies, and Fund A has made 10%, but all the other, or the majority of the other US large cap funds have made 20%. Fund A is clearly underperforming. On the other hand, Fund B, which buys small cap stocks, is down 10%, but most of the small cap funds are down 20. It's outperforming, so we want to keep it. So it's not just about the absolute performance. And this is where a trusted advisor can help put this in perspective, do the research, and make the recommendation. And then if we look at your allocation, and this is where rebalancing can come in. It's not market timing, but it's taking a look at where you're at, and ultimately it's going to force you to buy low and sell high. So in other words, if our allocation is 50% bonds and 50% stocks, and now the stocks shoot up because the market went up, and we have 70% in stock and 30 in bonds, by rebalancing, it says we must sell some of the equities that are up because we want to get back to 50%. So the asset allocation is something you decide with your advisor, and then you maintain it. That is going to force you to rebalance and not time the markets. You should rebalance whenever the portfolio becomes significantly out of allocation. So this year, for our clients, we ended up rebalancing twice in March and April, and then really didn't do much until now. By sticking with an allocation that meets your needs and your risk tolerance, you're not going to make emotional decisions as long as you're disciplined enough to follow that. The reason your allocation will change is because your needs or objectives have changed, not because of markets or speculation. It's interesting that, we talk about wanting to be a seller of pans, not a prospector. So during the gold rush, most of the would-be miners lost money, but the people that sold them picks, shovels, tents, and blue jeans made a big profit. We don't want to be the miner. We want to look at selling the picks and the shovels, not speculating. So there are a lot of threats, certainly, but there are always a lot of threats. And the fact is, it's never the bus we see coming that hits us. It's generally the thing that we don't expect that's coming and causes an issue. But there are also a lot of things, a lot of reasons that we can be optimistic going forward if we look at, where we're at today. So one of the biggest reasons to be optimistic is all of the energy reserves we've discovered. The United States has become energy independent, and we're a net exporter for one of the first times in history. If we look at corporate profits remain at record levels in the United States. We're a leader in manufacturing. If we look at where we are in terms of the manufacturing sector, we outproduce any other country in the world on a per capita basis. In fact, we produce more than twice as much as China. Foreign investment has been flooding in the United States. And again, this is one of those risks as well. If there's significant changes to taxes or regulatory policy, it could shut off the tap on that. There are huge amounts of cash still sitting on the sidelines, both overseas and in the United States. In the last 2 years, because of changes to policy, we have seen a lot of reshoring of manufacturing and money coming to the United States. It'll be interesting to see what happens. But again, that's definitely a reason to be optimistic, especially if we follow through with some of the infrastructure projects that we are talking about. Restructuring of debt. Personal debt is at a very low level. Again, we hear about all the issues in the media, but both personal and especially corporate debt is at very low levels in dollar terms. And we have some of the best interest rates we've ever had. And then finally, innovation. As we've talked about, innovation continues. The United States is a leader in the world. Israel is perhaps the second biggest driver of innovation. And so that continues to accelerate the pace of change. It continues to benefit the economy, and hopefully we continue to see incentives for that. Now, we mentioned the manufacturing, and I think it's important to just touch on some of the numbers. The fact is Americans produce about 20% of all of the things in the world, with just 4.5% of the population. China makes about 17% with more than 3 times the population. So again, on a per capita basis, we are the world's leader in manufacturing. So hopefully the less regulation, less tax policy continues as far as that goes. But the impact is even greater, because if we look, while the US produces 20% of all the stuff on our shores, American companies collectively produce between 30 and 40% of all the stuff in the world. And a lot of that money has remained overseas because companies like Apple, like Facebook, like General Electric, like Levi Strauss do not want to pay tax on it. And so by keeping it overseas, they literally are paying no tax at all. Now, with some of the policy, we talked about the GILTI tax, they'll pay some. The question is, if you raise corporate tax rates in the United States, does it continue to drive businesses offshore? And we've seen that locally in Cleveland, for example. Eaton Corp is now an Irish company, and largely, I would say, because of the tax situation as far as that goes. So, as we start to look at these things, we've talked about some of the optimistic things. What are the challenges that lie ahead? And frankly, these challenges are pretty much the same challenges that we've had ever since we started doing this event 33 years ago. The biggest challenge that most people face is inflation. The risk that a dollar tomorrow is not going to buy what a dollar today does. With people living longer and things costing more, this is perhaps the biggest risk, that people will run out of money. It used to be, when we started doing this event, people retired at 65, they died between 67 and 70. Now, people retire at 55 and they never die. They live on, and they're doing more and more. We have a number of clients in their 90s and a handful that are over the age of 100. So if we look back over the last 20 years, regardless of what the government says, things cost more. Think about your own shopping. And so it's very important for portfolios and for planning to take into account that many of us could live into our 90s. And so We want to invest so that the money is growing. The fact is, if you die with a lot of money, that's not a problem. If you live too long, that can be a huge problem. And part of that too is medical expense. Planning not just for basic medical, but for long-term care. There's about a 55 to 60% chance that one of every couple is going to need some form of long-term care help, whether it's at home, in an assisted living, or in some other type of situation. We strongly recommend speaking to your advisor about asset planning. This is not Medicare planning to get rid of your assets. This is planning on how you protect your assets from catastrophic medical. Now, in the last year or two, long-term care insurance, depending on the state, has become very expensive and much harder to get. There are non-traditional types of long-term care that we'd strongly recommend looking at, primarily what's called life long-term care insurance. And again, your trusted advisor can help with that. This is also something when you're looking at your estate planning to consider. The last and the biggest risk, and we've touched on this already a number of times this hour, is making bad decisions based on the media, emotions, or just bad information. Just because it's on the internet doesn't mean it's true. And unfortunately, as we said, the vast majority of people now, their primary source of information is social media. That is not a good source of information. When we started doing this event 30 years ago, our role with our clients was, in many cases, getting them information because it was tough. You get an annual statement, perhaps, on your 401k. There were 3 news channels, ABC, CBS, NBC. There was the Wall Street Journal, the New York Times. Our role was, how do we get information to our clients so they can make informed decisions? Today, it's like drinking out of a fire hose. How do we sift through all of that information to get you what's relevant to your situation and your clients? And if we're making decisions with bad information, then obviously our decisions could be bad. As we move forward, we go through this cycle, and this has been true as long as people have been investing, back to the Greeks and the Romans and everything else. People get optimistic, then they get excited. They start to hear about their friends, making all this money. They have to get in. And then they're pretty thrilled, and then people get euphoric about how good it is. Now, it's interesting. What we find is people like to worry. When things are going up, they worry that they're going to go down. When things are going down, they worry that they're going down. And that can cause its own problems. But we get to this euphoric state where people look at their statements and they say, wow, look how well things are doing. And then we start to get a correction. This could be March or April. People start to get anxious. And then they start to deny it's happening. Well, this isn't going to keep happening. Then they get fearful. And then eventually they get panicked and they capitulate and sell pretty much at the worst possible time. If we look at March of this year, record amounts of money went out of the markets and into bonds. If we look at before the election, record amounts of money went out and into bonds. If we look at March of 2009, the market bottom at the time, record amounts of money went out. All of those times are when money should have gone in to take advantage. And this comes back to the market timing that we spoke about. This is exactly the problem. People get panicked, they get out, they miss it. Then they're depressed for a little bit, they start to feel better, there's some relief, they get back to optimism, they get excited, and they invest at the worst possible time. And the cycle continues. coming back up. So we need to try to take some of the emotion out of it. We need to take into account that the information we're getting is often wrong, often incomplete, and usually irrelevant, because our decisions should not be based on the information that's just out there. The decisions need to be based on us. As we look forward to the next year and even the next month, there's going to be a tremendous amount of information thrown at us. And ultimately, from a political standpoint, I'd suggest look at the actions. Don't listen to what politicians are saying, because what they're saying is pretty much anything they can to get elected. So, what's next? One, ask the right questions. Ask them of yourself. Ask them of your trusted advisors. Work with professionals. Just as we suggest clients need to work with an attorney, they should also work with a CPA, an insurance expert, and the financial planner that's the quarterback of all of it. Now, admittedly, we take a different view. Our philosophy is what we call personal vision planning. We don't believe that planning or decisions should be based on the investments. That should be based on you and your vision. And ultimately, because of that, what's happening with markets, the economy, etc., doesn't really matter. You can do well over time regardless. So, with all that being said, I appreciate everybody's attention. I don't see that we have a lot of questions at this point, so we're going to continue with the program this morning, bring up our next set of speakers momentarily. Today's program, it's interesting because this is virtual. We have some of the leading experts in their respective areas across the country because we can meet this way. I do hope you'll take advantage of all of the amazing speakers and the topics that we selected based on your feedback and based on what's happening in the world today. So in that regard, our next speakers are Frank Amanat and Greg Gutzler. Greg is a partner at DiCello, Levitt & Gutzler, as is Frank. They're also co-sponsors of today's event. DiCello, Levitt & Gutzler has partnered with us the last couple of years to bring you this very unique event. DLG is a well-respected litigator. They've represented both corporate clients and consumers in some of the largest cases in the country. Now, Greg is an experienced trial attorney. His track record results in a number of high-stakes cases, handling all aspects of complex legal litigation, including securities fraud, antitrust, Lanham Act, whistleblower, ERISA, and RICO. Greg has litigated extensively, is previously a partner in an Am Law 100 defense firm. His education includes his degree from the University of Michigan Law School and his undergrad from UC Berkeley. Frank Amanat is also a partner at DLG, has almost 3 decades of litigation expertise, really shepherding some of the biggest cases, including the single largest recovery the Department of Justice ever obtained in a civil penalty litigation under FERA. Prior to joining DOJ, Frank actually spent 24 years at the DOJ, including more than 2 decades as an assistant U.S. attorney and senior counsel in the attorney's office. Frank and Greg are indicative of some of the speakers that we have today with some of the best credentials and CVs. From 2013 to 2018, Frank served as lead counsel for the government in the successful investigation and prosecution of Barclays Bank and 2 of its former executives for fraud in connection with the sale of residential mortgage-backed securities. The $2 billion settlement, which was reached in 2018, is actually the largest single recovery the DOJ has ever obtained in this type of case. Frank went to Harvard Law School, graduate cum laude, undergrad, University of Pennsylvania. He was the editor of the Harvard Law Review, volumes 103 and 104. So with that, I'd like to introduce Frank and Greg.
Good morning, everybody. My name is Greg Gutzler at DeCello Levitt Gutzler, and I am very happy to be here today with my partner, Frank Amanat. When we first talked to Randy about doing this presentation, I was very excited about doing it for a couple of reasons. One is I've grown to really respect and admire Randy and his client base, all the things he does for the community as well as for his clients. So that's been very exciting for me. And we were trying to think of what would be a good presentation, what has practical impact for the people that be on this phone call. I understand there are a breadth of professionals on the call and that everybody may have different interests. Some may be physicians, some may be lawyers, some may be financial hedge fund people. It doesn't matter. So what we try to do is figure out with that broad base of people, can we find a topic that may resonate with everybody and not get too esoteric in the weeds? And so if we could start with the first slide, what we're going to talk about today is going to be the Anti-Terrorism Act. And Frank, if you can go to my portion of the presentation, I think this is your portion. But what we're going to do, Frank gets that set up, that's no problem, is what I want to talk about is some principles that underlie any financial transaction and show how these underlying principles can apply to the Anti-Terrorism Act.
He has
The
a
Anti-Terrorism
separate
Act is a federal statute that was intended to,
this is mine,
purported to intend to stop the flow of money to terrorist activities. And the way in which it relates to and can be associated with general financial principles is follow the money and know your customer. So the very principles of due diligence, the principles of knowing your customer are absolutely critical. And if you're not careful, you may find yourself in a situation where the Anti-Terrorism Act, the federal U.S. statute, which is very powerful, may be implicated. So what we wanted to do today is talk about the general principles of the Anti-Terrorism Act. This is not meant to be an esoteric legal dissertation in which there is absolute precision and is absolutely comprehensive. And the reason for that is that if we were to do so, this would be an approximately 4 to 5 day presentation because the ATA, the Anti-Terrorism Act, I'll call it the ATA, is extraordinarily complex. It is complex in that it has a series of blocking statutory connections, and you have to follow the statute through this maze of different statutes and definitions. Not just that, but when you look at the ATA, you have to follow what they call the chain of statutory incorporations. You also have to follow the definitions that are embedded within the statute, and you also have to overlay that with common law principles. That is a long way of saying it is impossible to give absolute precision today as to the ATA, but we are going to provide a conceptual framework so that you can perhaps say, hey, wait a second, I never thought of this before, but this may be a situation that merits further investigation not just because of the financial laws, KYC, AML, money laundering things, but also, am I violating a civil statute? So when we talk about the ATA, we need to understand that the ATA provides very strong penalties. It has a criminal component, and what we're going to talk about today is the civil component. The civil component meaning that a person can bring a lawsuit against an entity that violates the ATA for damages, money damages. And an important thing to remember is that the ATA has a very aggressive damages framework. And a person who has been injured under the ATA can sue not just a group that did the terrorist act, but anybody who provides support to that group. And the key aspect here is to talk about who can be liable. So we're going to try to get the right slides up here in a moment. So if you just give us a second, I can get going with it. But let me start with the ATA, the damages part. The reason there needs to be extreme caution when engaging in any activity here that may implicate the ATA is the damages regime is very, very powerful. First of all, a person who has been injured includes not just the actual person who has been killed or the person who has been hurt, but any of their survivors or heirs. In other words, to make it simple, family members who have lost, have experienced pain and suffering, mental anguish, loss of consortium, do have standing under the statute to sue for the death or injury to a loved one. Not just that, but the damages that have been given out by judges and juries have been extraordinarily high. We are talking $5 to $10 million per person relating to the loss of a loved one. For example, there have been cases where a soldier was injured overseas by an act of international terror. And let's say they have 10 family members. Each family member was getting between $5 and $10 million. Now, in addition to that, what a jury wouldn't know is that after a jury renders a verdict, the judge is required, per the statute, to triple the damages. So you now have a case where you have, let's say, 10 people who have lost their loved one. Each gets $5 million at least, and a jury could determine that. Now you're up to 50 million, and the judge will then be required to triple it. You're now up to $150 million in damages related to the injury to one person. So as we think about the ATA, it is important to know that the stakes are extraordinarily high. And the components here that we need to talk about when we get the slides going will be what are the core elements to look at here, and what are the key practical aspects for you as engaged in almost any industry. And you're going to see how wide ranging it is. And it may sound crazy, but you have banks, you could have people who are selling materials, and you could have, for example, you're going to see a case study that Frank's going to talk about, a company that sells bananas. And it's actually a fascinating case involving a well-known banana company, Chiquita, which is one of the leading ATA cases. So if we can get the slides up, that would be fantastic. And I'm going to go through some of the high level. Okay, so I've been told that we're going to pull up the slides, so I'll stop saying that. And what we're going to do then is we're going to go through the basic components of the ATA. Again, this is not meant to be overly legal. It's meant to be practical. However, there will be some legal aspects that I will try to use modern, contemporary English with, and not legalese, because lawyers like to make up expressions and all these things to make it difficult. I'm going to try to make it a little more approachable so that you can get a feel for it. So as we get going here, the key component here for civil relief under the ATA is a statute that is codified at 18 USC section 2333. Not important to memorize that, but it is important to know that that Congress has given civil relief options to people who have been hurt by an act of international terrorism. And the way the statute works, like I talked about, is that any U.S. national, it's a little broader than citizen, but for purposes of our discussion, let's just talk about somebody who resides in the U.S. or is a citizen of the U.S. That's the simplest way to put it. Anybody who has been injured can bring an action against any entity that supported the entity that hurt the loved one or hurt that person themselves. So again, the person injured and survivors and heirs can bring an action for things such as economic loss of consortium, pain and suffering. The key aspect here will really be pain and suffering, and that is a jury question. A jury can decide whatever they want are the damages. And if you pick the right jury, you could have astronomical damages. So the key here now is to talk about what is an act of international terrorism. That is the key component here that starts the analysis all the way through. So you need to show you or your loved one was injured by an act of international terrorism. So as we move through the statutory framework, international terrorism is defined in the statute by Congress in 18 USC 2331. And it'd be nice if we can pull up the slides so I can talk to the slide. But without that, I'm happy to go forward looking at this. So an act of international terrorism is going to consist of three components. So three components, each of which have their own set of definitions and complexities. And again, I'm going to try to keep it basic. So an act of international terrorism is element number one will be activities that involve violent acts or acts dangerous to human life that violate the criminal laws of the United States or a state of the United States. So again, violent act or an act dangerous to human life and violates a criminal statute of the United States. Now, as we can see here from this slide, I've highlighted violation of the criminal laws because that is going to be a part of the next slide. But let me speak to, under here A, involve violent acts or acts dangerous to human life. That is going to be a critical inquiry to think about when we talk about supporting a group that engages in terrorism, because that's where we're heading next in this analysis. And so if we think about it, it is going to be a relatively broad definition of what could involve here an act dangerous to human life. So for example, let's talk about financial services. So Randy Carver handles a lot of people's money. And so when we talk about it, is Randy, by moving money around and investing money and doing things of that nature, perhaps making wire transfers, perhaps wiring money to certain places? That's where the analysis gets more interesting, because it's very obvious that Al-Qaeda planting a bomb and blowing up a building is an act of international terrorism. That's pretty clear. That is clearly a violent act. It's clearly an act dangerous to human life. It's clearly an act that violates the criminal laws. But where the statute gets more interesting is that it's going to try to stop all the people that are in the chain of causation that can cause something like that to occur. Who are the people that got the money to Al-Qaeda? Who are the people that perhaps sold the materials to make bombs? Who are perhaps the people that concealed the activities of Al-Qaeda doing that? That's where the statute packs a lot of punch. And that's where we want you to start thinking about the practical aspects. So is it possible that a financial institution that is knowingly transferring money to, for example, Al-Qaeda is committing an act dangerous to human life? The answer is yes. It is very, very possible, subject to a lot of nuances. But you need to be aware of where your money's going. You need to be aware of following the money and knowing your customer. So let's talk about that. So we're going to talk about element A, involving violent acts or acts dangerous to human life that are a violation of the criminal law. So we're going to go to the violation of the criminal law. Here's where we talk about material support. So let's go to the next one here and how we talk about what is a violation of criminal law that may be supported. So here we go. It is a violation of criminal law under 18 U.S.C. 2339A to provide material support for a terrorist act. And so now you can see how, with respect to the definition before on the previous slide that talks about a violation of criminal law, you can violate criminal law by providing material support to any group that engages in a terror act, if you know or intend that the support you are giving is to be used in preparation for, in carrying out or concealing an enumerated crime, such as the killing of a U.S. national internationally, or a kidnapping, things of that nature. So what we're talking about here is providing any type of material support. And the statute, here's where we have the embedded definitions, is very, very broad. And as you can see, one of the things that is specifically enumerated as a, quote, material support is financial services, for example, currency or monetary instruments. And by the way, it is a huge definition. I culled it down for this presentation to talk about something that is much more germane. And let's talk about financial services. And Randy Carver Financial Services, this is a perfect opportunity to talk about that and talk about how there are practical implications to what Randy does or to what you do and how you do it. So again, material support is a way of material support for a terrorist act is a way to violate the U.S. criminal laws that may implicate the international terrorism definition, which ties into a civil claim against an entity who engages in those acts. So, as we talk about it here, the first question you're going to ask, and the key is, what does intent mean? And so we're going to talk about that as we look at 18 USC 2339B. This is another statute that provides criminal liability for anybody who provides material support to a group that has been designated a foreign terrorist organization by the United States Secretary of State. Very similar to the previous statute, which was 18 USC 2339A. The real difference here is that it takes away a little bit of the specificity with respect to what the person intends to do, but it supplies in here where if you provide any type of material support, same definition, which is very broad, to a group that has been deemed an FTO, you could have liability. Okay, so we have 2339A, which talks about material support to a group that commits a terrorist act. 2339B, providing material support to a foreign terrorist organization. And then the next statute, 18 USC 2339C, let me just sum it up, providing financing to a group that engages in a terrorist act. So now this is very specific to financing. And recall that the material support definition in the two previous statutes also would encompass potentially, quote, financial services, as we saw from the definition. 2339C is just laser focused on financing terrorism. And again, I've highlighted the word intention. So let's talk about an easy example of intention. Let's go to the next slide. So again, let's talk about Randy Carver, who handles a lot of money. He handles a ton of money. So let's talk about a very extreme example. Randy Carver has a well-known doctor who he's known forever, who does great work. He's a great surgeon, or she's a great ophthalmologist, whatever it is. And this person says, I'd like to transfer some money to this great charity. It's an animal shelter. And Randy looks at the customer, looks at the animal shelter. It's truly a charitable organization. It has puppies and dogs on it. There are no known ties anywhere. It's just a great organization. Now, if Randy transfers money to that charity on behalf of that customer, and that charity ends up being a front for Al-Qaeda, is Randy Carver going to be in trouble? The answer is almost certainly no. Okay. Now, I can give you a different example. A customer says, I want you to transfer money to, let's say, back in the day, Osama bin Laden. Okay, it's a very extreme example, but it's meant to talk to you about how does Randy Carver, as a financial service provider, how could he get himself in trouble? The standard for intent is not actual knowledge per se. Okay, now that certainly qualifies, all right? But recklessness or deliberate indifference is sufficient. So again, know your customer, do your due diligence, and don't just blindly move money around to somebody, for example. That can get you in trouble. And so even if Randy's subjective intent, let's say, was totally pure, and he just says, well, I think this is an okay thing, to the extent that any reasonable person could have easily determined that transferring that money was a risk or providing material support, you've now got yourself into a very, very dangerous situation. So again, the intent component of providing material support is one that is governed under the law by, were you reckless? Were you deliberately indifferent? Did you put on blinders and say, oh, I don't really care. It's none of my business. The ATA actually makes it your business. It imposes upon you an obligation to behave reasonably. And again, follow the money, know your customer, do your due diligence when you are providing services. And Frank is going to give some case studies that really bring light to this. But I really like this quote here from a Seventh Circuit opinion. And what it says is, To give money, and let me just read it quickly here. To give money to an organization that commits terrorist acts is not intentional misconduct, unless one either knows the organization engages in such acts, so that's actual knowledge, or is deliberately indifferent to whether it does or not. And it continues. And then it says, when the facts known to a person place him on notice of a risk, he cannot ignore the facts and plead ignorance of the risk. You cannot stick your head in the sand. This applies to KYC principles, AML principles. And so this statute is meant to craft a practical construct around how do things really work. And you can't get out of liability by saying, I truly did know, and I really thought it was a good thing. That's not good enough. You need to do your homework. And so that's how you can unwittingly provide material support, but you have to do your homework. So let's go to the next prong and recall, let me give the backdrop. We can stay on this slide, but with this backdrop, remember 2333 imposes potential civil liability on anybody who engages in support for international terrorism. And now we've covered violent acts or acts dangerous to human life. And let me touch again on dangerous to human life. An example of dangerous to human life is, in one case, says, handing a loaded gun to a child. That is an act dangerous to human life because you realize that a child is not equipped to safely deal with that weapon. Providing money to a terrorist group can be deemed an act dangerous to human life because you are supplying the lifeblood to a terrorist group. They need money. They use money to hurt other people. And recall that the rationale, the underpinning, the statutory policy, the legislative policy for this statute was to stop the flow of money and support to terrorist groups because they need money. So that was the underpinning. And that is the rubric that you must apply to looking at the statute. So we've talked about violation of the criminal laws under A, and that was the material support, for example, the material support statutes we talked about. So let's go on now to the next prong. And you can see here now it says that the activity that is the International Terrorist Act that hurt the U.S. national must appear to be intended to. Again, appear to be intended to. Crucial language in the statute that we'll talk about at a high level. Appear to be intended to intimidate or coerce a civilian population, or influence the policy of a government by intimidation or coercion, or affect the conduct of a government by mass destruction, assassination, or kidnapping. And those are sort of the hallmarks of what we all practically in common sense connote with terrorism. That's a really scary thing. It really makes me want to hide. It really makes me fear for my life. It makes me fear for my country. It makes the government say, oh my gosh, maybe we should get out of the Middle East, for example. That's exactly what we common sense think of as a terrorist act. So let's talk about what appears to be intended. And here it is. So when it says appear to be intended, it is not the subjective feeling of somebody. It is an objective appearance looking at the totality of the circumstances, looking at what occurred, looking at what was foreseeable. Again, there's sort of a practical construct. You can't put your head in the sand, and the actor, this defendant, the person who did the thing, let's call it the material support. Let's call it transferring money to a terrorist group. That's a very easy way to do it, by wire transfer. If I'm on the outside and I'm an objective person and I say, what do I think that financial provider was intending to do? And I don't let that person put their head in the sand. I am permitted as the objective viewer, observer. Again, this is the court crafting a hypothetical objective observer. What did that person, what can we ascribe to that person? What type of knowledge can we impute to that person? And so if the fact pattern is that the financial provider was told, again, I'll give a very extreme example because that's the easiest way to really understand the purpose. The example here is the financial service provider was instructed to wire $5 million through Swiss banks and through other banks and push it around the globe a few times, and then have it end up in the hands, being instructed to have it end up in the hands of a known Al-Qaeda leader. How about that? And the person says, well, my customer told me to do this. Well, now as the hypothetical objective observer, what do I think that person was doing? What does it appear that person was intending to do? So we know that Al-Qaeda is a terrorist group. We know that Al-Qaeda commits gruesome crimes. We know that Al-Qaeda kills U.S. nationals, and they kill them overseas or wherever they can find them. We know that Al-Qaeda does that to terrorize people, as we know, intimidate, coerce governments and civilian populations. So by the financial service provider providing that service, that would most certainly fall within the material support statutes of providing material support to, in this case, a foreign terrorist organization or a group that engages in terror, and 2339C, financing terrorism. So when you look at that fact pattern, and we know what Al-Qaeda does, we know that they need money. We know that it's a pretty fair thing to say that a judge or jury may say, you know what, that most certainly appears to me as an objective observer that person was intending to be a part of this intimidation and coercion. And so here's a quote from a case that says, for example, in our fact pattern, and given such foreseeable consequences, such donations or wire transfers would appear to be intended to intimidate or coerce a civilian population or to affect the conduct of a government by assassination. That's an example. That was a case where charities, they weren't really charities, they were front groups. These charities were funding Hamas, and Hamas, as we know, is a terrorist group that kills people. So anybody who was funding the operations of a group that engages in terror or should know if they're reckless, if they're deliberately indifferent, if they should know, then you've got yourself in a situation where you may be liable under the Anti-Terrorism Act. And again, please note, there are tons of nuances. The case law is actually varied over the circuits because the statute is so complex. And starting in 2016, the court started to refine the analysis a little more. So again, please be aware that this is meant to be a high-level overview. Now, in 2016, Congress added a new component to a situation in which an entity can be potentially liable under the Anti-Terrorism Act. And it added under the Justice Against Sponsors of Terrorism Act, everybody calls it JASTA, aiding and abetting, which is sort of a well-known term, mostly in the criminal context here, that people have heard of aiding and abetting a crime. So under JASTA, which is a part of the overall anti-terrorism regime, a defendant, for example, again, a financial services provider, could be held liable under the Anti-Terrorism Act, under the JASTA component for aiding and abetting. And you can see here the components. The defendant aided a third party who performed a wrongful act that caused an injury. Again, for ease, let's call the third party here Al-Qaeda. And the defendant here is a financial services provider who transferred money, recklessly, deliberately indifferent, that it could have been going to Al-Qaeda or it was going to Al-Qaeda. Next, the defendant must be generally aware of his role as part of an overall illegal or tortious activity at the time of the assistance. Again, easy fact pattern, transferring money to a terrorist group. And the defendant must knowingly and substantially assist the principal violation. We could talk about what it means to knowingly do it. Again, look to indifference or recklessness. It's not actual knowledge always. Actual knowledge certainly satisfies the statute, but you could also be recklessly indifferent where the court will impute to you knowledge. You can't put on the blinders. You got to follow the money. You got to know your customer. You have to follow the money, just like money laundering. And the principal violation here is, let's just say, make it even easier. Transfer money to this person to buy a gun or a bomb. How about that? very, very simple. Again, I'm giving really easy examples, and I could give you much more nuanced examples, and we could have an esoteric discussion, but I don't think this is the right time for that. The last component that was added under JASTA was conspiracy liability. And that's sort of the traditional conspiracy that we all know about from TV shows or criminal law, where there's an agreement and there is a participation in an unlawful act, and the people were doing it as part of a conspiracy. There are different types of conspiracies. There's the hub and spoke conspiracy, but that's neither here nor there for purposes of this discussion. Again, the overarching principle here is you can be found liable if you provide material support. Material support includes money, and the material support intent that is required under the law can be one in which you are reckless or deliberately indifferent. So the takeaway from the statutory framework is follow the money, KYC, know your customer, and you cannot hide behind blinders. You cannot put on a cloak of ignorance, because the court will not permit that. The court will impute to you knowledge based on the circumstances, based on the foreseeability of harm, based on the people with whom you're doing business, based on your actions. So what's going to go on now is Frank is going to go through some very interesting case studies. And one of them is a case that I actually filed, and it's a very interesting case. And these are meant to not make you an expert in the case law, but to make you see, help you see the various ways in which people can get themselves tangled up in the ATA. And the Chiquita case is my favorite example, where the subjective intention was actually a good intention, and that has some qualifications. But the intent behind that case, which Frank will talk about, was subjectively a benign intent. But you're going to see how that's not good enough. You better be careful. So I appreciate your time. I would love to answer questions. Perhaps we could do that in a different form or later. I'm not sure how that works, but I very much appreciate the opportunity, and I hope I didn't pick on my friend Randy too much. So thank you very much, and Frank's going to do a great job.
Great. Thank you so much, Greg. And thank you, Randy, for that introduction at the beginning. My name is Frank Amanat. I'm a partner at Tichel Levitt Gutzler, and I'm happy to follow up on Greg's presentation by giving some illustrative examples of how the cases in this space have developed. I want to mention that as Greg alluded to, the policy underpinnings of this statute in terms of why Congress passed this statute, it's of course to provide a deterrent to terrorist organizations, make it harder for them to commit acts of terrorism by cutting off the sources of assistance and financing to them. And because most terrorist organizations operate in black markets or in the shadows, they're very often not reachable. And in terms of being able to sue them directly for the consequences of their terrorist actions. So Congress wanted to create a mechanism that would allow people to go after others who are in the orbit of terrorist organizations who contribute to it. And so the cases in this space, as we'll see in some of these examples, tend to focus in kind of 5 different types of entities have gotten sued. And Greg alluded to a number of these. Most common ones that we'll see are banks and financial institutions. There's also charitable organizations, companies that pay for protection, social media platforms, and entities that purchase goods from foreign terrorist organizations or their middlemen. These tend to be the most common types of defendants who get sued under the ATA. Now, in presenting these examples, I want to, part of it is to, hopefully give some additional insight into the general principles that Greg discussed. But I also want to show that these cases can be hard. Frankly, the majority of cases brought under the ATA have not been successful for one reason or another. One of the main reasons for that is, as Greg said, this is a treble damages statute. The statute allows a successful plaintiff to recover 3 times the amount of his or her damages. And because of that, courts tend to scrutinize these claims very carefully to make sure that that kind of a damages assessment is warranted. And there are a lot of nuances to these. But let's start by talking about some of the cases involving banks and financial institutions. In these cases, plaintiffs typically accuse banks of having facilitated economic transactions for foreign terrorist organizations, including by providing basic banking services or other kinds of access to cash, especially when international sanctions or other enforcement mechanisms are specifically meant to cut off access by terrorist organizations to legitimate banking institutions. There's often also an accusation that the banks are effectively laundering money for terrorist organizations by facilitating the transfer of funds. And because most foreign banks have branches or offices in this country, the statute provides a mechanism to go after even foreign banks that whose primary involvement with terrorist organizations is overseas, but who can be jurisdictionally made subject to the statute by virtue of their U.S. presence. As I said, most of these cases have failed, either because the plaintiffs have not been able to prove causation, a causal relationship between the actions of banks and actions of terrorist organizations, or else because they haven't been able to prove intent. So the case law has become more challenging in recent years, especially where plaintiffs have alleged primary rather than secondary liability. So when I say primary liability, that refers to the notion that the bank itself, the defendant itself, is accused of having somehow directly participated or contributed to the terrorist activities, as opposed to secondary liability, which is the aiding and abetting or conspiracy liability that that Greg was touching on towards the end of his presentation. So let's look at a few examples. So I'm going to focus on this case called Zapata, and I do this at some peril because this was a case that my partner Greg Gutzler filed and litigated and lost. But it is an interesting case that I want to that I think nicely illustrates some of the nuances here. So this was a case that didn't involve what you might traditionally think of as terrorist organizations, such as Hamas or Al Qaeda, but rather involved Mexican drug cartels, who, in fact, are, although they haven't been designated as terrorist organizations by the U.S. government, they certainly engage in a range of terroristic activities. So the victims of a number of violent acts that were perpetrated by Mexican drug cartels such as Sinaloa and Los Zetas sued this British bank called HSBC and a number of its subsidiaries under the ATA, alleging that they committed acts of international terrorism when they laundered drug proceeds for these cartels. And the complaint was very creative. I mean, it detailed numerous atrocities that were committed by the cartels that were of a terroristic nature, such as gruesome public displays designed to intimidate and coerce, attacks on children and women, mass murders, and so forth. Now, the plaintiffs alleged that HSBC Bank routinely opened U.S. dollar-denominated accounts for these for individuals that were known or suspected money launderers, and also accepted large cash deposits from them. And the allegation was that these banks had an obligation under the Know Your Customer or KYC rules to do due diligence and see who they were dealing with, and they failed to do that. And the allegation was that these deposits were used for money laundering, and the cartels used HSBC to inject cash into the financial system through wire transfers and purchases of bulk physical currency, which the cartels then used to integrate the proceeds of the drug sales into the legitimate economy. And then they use that to buy buildings, factories, equipment, and so forth to support their violent activities. Now, it was undisputed that HSBC had deliberately maintained substandard anti-money laundering policies and that it had failed to conduct appropriate due diligence. In fact, HSBC had been investigated by the Justice Department and entered into a kind of a plea agreement called the Deferred Prosecution Agreement, in which it admitted laundering at least $881 million in drug trafficking proceeds, and it paid almost $2 billion in fines. Now, the reason this is important is that the ATA has a provision in it which basically says that if an entity is criminally prosecuted and in the course of that criminal prosecution, they either admit or are found guilty of having engaged in certain actions, when they subsequently get sued under the ATA, they're not allowed to then dispute in the civil case the actions that they admitted to in the criminal case. So it seems like this case had everything going for it. But unfortunately, it did get dismissed on the bank's motion. So there's a couple of nuances here. So Greg mentioned the difference between 2339A material support and 2339B material support. The difference being whether the defendant has been designated as formally designated as a foreign terrorist organization. Because the cartels had not, the grounds for liability are more limited. And this took place before JASTA was passed. So aiding and abetting liability was not yet available. So the bank could only be held liable if it directly committed acts of international terrorism. And that required, as Greg intimated, that the plaintiffs be able to show not only that HSBC was a bad actor, but that its bad actions appeared to be intended to intimidate or coerce civilians or influence government policy. And the court decided that the bank's motivation was greed, not terror. It was motivated by economics, not by a desire to intimidate or coerce. The court also dismissed the ATA claims because it decided that the plaintiffs had failed to adequately or plausibly allege a causal relationship between the bank's actions and the injuries that the plaintiffs suffered. The statute requires a showing of what's called proximate causation, meaning that there's a sufficiently direct relationship between the conduct in question and the injuries for which recovery is sought, which goes into issues of foreseeability, directness, and substantiality. And the court found here that the direct link was missing. So there's a quote here from the case. I'll just read real quick. What plaintiffs do not allege, however, is any relationship between HSBC's money laundering and the acts of violence perpetrated against them. The plaintiffs do not allege, for example, that the cartels require laundered money to carry out any acts of violence in Mexico, let alone the specific atrocities inflicted upon plaintiffs. Moreover, the cartels are not cash-poor organizations. Indeed, plaintiffs acknowledge that the cartels have abundant cash resources, and there's no plausible inference that the cartels would not be able to commit these acts of violence without HSBC laundering their money. So what this case illustrates. Uh, Excuse me one second. Scott, can you please mute the background noise? So what this case illustrates is that these cases can be very difficult to win and require careful attention to pleading following the statute's elements. Okay, so let me just give excuse me, Director, could you please mute the background noise? I'm hearing a lot in the background. I'm sorry. Um, let me just give a few quickly give a few other interesting examples. This Lind case from the Second Circuit, that's the Court of Appeals in New York, uh, was a case brought by U.S. citizens who'd been victims of some terrorist attacks in Israel, and their family members who sued a Jordanian bank alleging that it had provided financial services and supports to Hamas, Islamic Jihad, and other terrorist organizations. Um, the bank had provided financial services to charitable organizations accused of being fronts for Hamas and to Hamas itself. Um, Now, this was a case that actually went to trial, and the plaintiffs got a $100 million jury verdict against the bank. But the Court of Appeals ultimately reversed that verdict, uh, finding that the judge had erroneously instructed the jury as to what counts as an act of international terrorism. Another case out of that same court against the same bank was Gill, which had a similar fact pattern. This was decided by the famous Judge Weinstein in Brooklyn, my old stomping grounds, where I was in AUSA. And here, the Judge Weinstein granted summary judgment to the bank based on insufficient evidence of scienter, that means knowledge or intent, as well as um, probable cause. Another famous case is this Kemper case, also from the Seventh Circuit, that was brought by the mother of a service member who had been killed in an attack in Iraq by Hezbollah, who claimed that Deutsche Bank had violated U.S. sanctions to engage in banking transactions that allowed Hezbollah to finance its terrorist activities. Again, the court dismissed because it found that the actions couldn't have caused the soldier's death and didn't constitute material support. This Rothstein case against UBS kind of had a similar fact pattern. And again, the court's language here is interesting. The complaint does not allege that UBS was a participant in the terrorist attacks that injured plaintiffs. It didn't allege that UBS had provided money to Hezbollah or Hamas, or that U.S. currency that UBS transferred to Iran was given to Hezbollah or Hamas. And it also didn't allege that if USB had not transferred the money to Iran, Iran, with its billions of dollars in reserve, would not have been able to fund the attacks in which plaintiffs were injured. So, and then there's a case arising out of the terrorist attacks on 9/11, with kind of a similar set of findings. And again, the Second Circuit rejected it, saying it was not persuaded that providing routine banking services to organizations and individuals said to be affiliated with Al Qaeda approximately caused the 9/11 attacks. So, and the last one I'll speak about here is this case against BNP Paribas, which related to terrorist attacks at U.S. embassies in Africa. And the victims of which brought this action against a French bank, alleging that it provided assistance to Sudan. Once again, the court dismissed it for lack of causation. So these cases can be really, against banks and financial institutions, can be tricky to bring. But in the last few years, there have been a few who, basically learning from the lessons of some of these earlier cases, have been able to successfully plead the connection between the bank and the terrorist activities. The next category I want to talk about is charitable organizations, which are sometimes accused of either being fronts for terrorist organizations or raising money for them. The most significant case in this space is the Boehm case that Greg touched on a little bit. was a suit brought by the parents of an American Jewish teenager who was shot to death by two men at a bus stop in Israel. It wasn't disputed that the teen's assailants were members of Hamas. And the parents sued a number of charitable organizations that had raised money for Hamas's social service programs, as well as several individual donors. The defendants didn't seriously dispute their ties to Hamas, but argued that they themselves did not commit acts of international terrorism and that they were only supporting Hamas's social services programs. The court rejected those defenses, and the plaintiffs in that case won a judgment of $156 million. As Greg said, when these cases are successful, the damages awards can be quite substantial because of the treble damages figure. So, and on appeal, the Seventh Circuit in Chicago, sitting as a whole full court, affirmed the judgment. It's one of the few major cases in which the plaintiff successfully sued and recovered under the statute, at least in terms of a substantial victory. And some of the language that the court used here is interesting. So they had no difficulty finding intent. As they put it, to give money to an organization that commits terrorist acts is not intentional misconduct unless one either knows that the organization engages in such acts or is deliberately indifferent to whether it does or not, meaning that one knows there is a substantial probability that the organization engages in terrorism, but one does not care. If you give a gun you know is loaded to a child, you know you are creating a substantial risk of injury, and therefore your doing so is reckless. And if the child shoots someone, you will be liable to the victim. That you did not desire the child to shoot anyone would be irrelevant. A knowing donor to Hamas, that is, a donor who knew the aims and activities of the organization, would know that Hamas was gunning for Israelis, that many U.S. citizens live in Israel, and that donations to Hamas by augmenting its resources would enable Hamas to kill or wound or try to kill or conspire to kill more people in Israel. And they said that this, therefore, meets the definition of appears to be intended. They also didn't have any difficulty finding causation here. What they said is the case is only a little more difficult because Hamas is and was at the time of David Bohm's death engaged not only in terrorism but also in providing health, educational, and other social welfare services. But if you give money to an organization that you know to be engaged in terrorism, the fact that you earmark it for the organization's non-terrorist activities does not get you off the liability hook. They go on to explain that the reason is because money is fungible, and you may call it social services, but then they can just move money from the social services account to the terrorism account. Anyone who knowingly contributes to the nonviolent wing of an organization that he knows to engage in terrorism is knowingly contributing to the organization's terrorist activities. And that is the only knowledge that can reasonably be required as a premise for liability. So the next category I want to talk about are protection payments, where companies with legitimate business operations in areas controlled by terrorist organizations pay them to leave their workers alone or protect them from acts of violence. And as Greg alluded to, the most interesting case in this space is the Chiquita Brands case. So this involved the terrorist organization in Colombia called FARC, the Revolutionary Terrorist Organizations. And Chiquita had a number of substantial banana growing operations in Colombia. And it began receiving threats from FARC to its employees there, and then demands from FARC for protection payments. Initially, it acceded to specific extortion and ransom demands that FARC had made, but over time, it actually negotiated with FARC for volume discounts and other reduced settlements of these protection payments, all of which were authorized at the top levels in Chiquita's Cincinnati headquarters. And many of them were remitted through professional negotiators and shady intermediaries, including some who hid cash in a spare tire in the back of a Jeep to be paid to FARC. And over time, Chiquita gave FARC quite a bit of money. Now, Chiquita was investigated and pled guilty to criminal charges of engaging in transactions with a specially designated global terrorist organization, and it paid a $25 million fine. DOJ said, regardless of the company's motivations, defendant Chiquita's money helped buy weapons and ammunition used to kill innocent victims of terrorism. Simply put, Chiquita funded terrorism. Now, Chiquita's counsel, who interestingly enough was Eric Holder, who subsequently would become the Attorney General of the United States, said in a press release, the company, quote unquote, funded terrorism. I would agree with that. Yes, in the same way that an extortion victim funds the mafia. The money that is extorted from the company and goes to FARC is not something that was willingly given. It was given at the barrel of a gun and threats. And this was Chiquita's primary argument, that they were doing this under duress and that they weren't trying to support the terrorist activities, they were just paying for protection. But the court rejected that argument, denied summary judgment, and said it made no distinction. The statute makes no distinction between voluntary and involuntary conduct, and it rejected a duress defense. And it also rejected Chiquita's argument that it didn't intend to commit acts of terrorism. I don't have time to read the quote here, but the gist of it is that the payments were intentional, and because Chiquita knew who it was paying and what that entity did, it met the definition of apparent intent, regardless of their actual intent. It also rejected their argument that they didn't cause the damages because it was clear that it was foreseeable to Chiquita what that FARC would use the money to commit violence. So I'm running out of time here. Let me just briefly mention, there have been an increasing number of cases against social media platforms such as Twitter and Facebook, arising out of their alleged quote unquote support for terrorism by giving them a platform for propaganda. The most famous of these cases is Crosby case from the Sixth Circuit. Virtually all of these cases have failed, basically on causation grounds, saying that the plaintiffs have no way of proving that Twitter or Facebook, simply by giving Al-Qaeda or ISIS a mechanism to spread propaganda, actually contributed to the ensuing violence committed by people who became radicalized by looking at that stuff. There's also the situation of legitimate businesses that purchase goods or services, typically from black market sellers, knowing or with reason to know that the goods were stolen or looted by terrorist activities. You see this, for example, where some companies buy oil that had been stolen by terrorist organizations or by entities acting in their favor. So forgive me for breezing through those quickly, and I don't know if we have time for questions because we're running out of time in our panel. But again, thank you for having invited me to speak on this panel. I hope some of these case studies were interesting and kind of illustrate not only some of the policy underpinnings of the statute, but also some of the creative ways in which it's been used to try to find justice for victims of terrorism and cut off the source of funding to terrorist organizations.
Got it.
Greg, anything you want to say in conclusion?
No, I'd just like to say thank you to everybody. This was a great opportunity, and thank you, Randy, and everybody for letting us do this. Thank you.
Awesome. So thank you to Greg and Frank. We are about halfway through our first day. If people have questions, please remember you can chat them. We will bring them up. The chat function's at the bottom of your app. And then, of course, if you think of stuff later, just feel free to email me or Kelly, and we can respond and or connect you to the appropriate person. So Following our day today, the next session is going to discuss employers' duties and responsibilities in reporting misconduct of their employees. A little bit similar now, looking in versus looking out as far as what we just talked about. And we'll discuss the ethical considerations as well as best practices surrounding the issues and best practices with an eye towards minimizing misconduct and potential liability at your clients' businesses. So presenting for this session, we're excited to have Leslie Brovner and Mark Peters. Leslie is the co-founders of Peters Brovner. Ironically, Mark is the other co-founder. They're a New York-based boutique litigation firm that focuses on internal investigations, white-collar regulatory defense, civil litigation, and then campaign finance and election law. Prior to joining and co-founding the firm, Leslie served as first deputy commissioner of the New York City Department of Investigation, DOI. And while in that role, Leslie directed quite a bit of complex criminal and civil litigation, and also oversaw the issuance of all agency reports and supervised the DOIs in the counsel's office. Prior to that, Leslie was a prosecutor for 2 decades at the New York State AG's office and also the Queens AG's office. And then lastly, Leslie served as chief compliance officer for New York State Liquidations Bureau. She received her JD from American University, the Washington College of Law, and her BA from NYU. Her co-founder, Mark, prior to co-founding Peters Brovner, Mark was the commissioner of the New York City Department of Investigation from 2014 to 2018. And while in that role, he supervised basically a 700-person law enforcement agency responsible for investigating corruption, waste, fraud, etc. within the city. As DOI commissioner, Mark worked closely with all of the city's major prosecutors' offices in bringing cases. Before his time as commissioner of DOI, Mark was a partner at an international law firm, Edwards, Wildman and Palmer, from 2010 to 2014. And finally, prior to that, Mark worked in the New York State Attorney General's offices as chief of public integrity, or as chief of the Public Integrity Unit and deputy chief of the Civil Rights Bureau. Mark graduated from the University of Michigan Law School, and he received his BA from Brown University. And again, if you guys have questions, feel free to chat them. And with that, I'd introduce Mark and Leslie.
Thanks, Randy. Good morning, everyone. Thrilled to be here. And we are going to be talking to you, as Randy said, about the legal obligation of employers to report the misconduct of their employees. Generally speaking, there is not a legal obligation to report on the misconduct of your employees. However, there are some specific statutory requirements. We're going to talk about those. And there's also some areas of law that are a little less clear-cut, and we'll discuss that as well.
Before we begin, let me give you a little bit of background beyond what Randy said about the law firm. Peters Brovner is a boutique firm that specializes in investigations and in assisting corporate entities that are being investigated by various regulatory and law enforcement agencies. And as Randy mentioned, before founding Peters Brovner, Leslie and I ran the New York City Department of Investigation, so we were essentially the city's inspector general.
So we're going to talk about the obligations to report employee misconduct. But before we do that, let's look at the wrong way to think about it.
Okay, now that we've looked at the wrong way to think about this, let's talk about the right way. So let me give you a quick overview of the topics that we are going to cover in this next hour. First, we're going to talk about some federal reporting requirements, some instances where federal law requires or makes it best practice to report employee misconduct. Then we're going to talk about a couple of states that have criminal reporting requirements, that actually state laws that require reporting criminal conduct by employees. Then we're going to talk about what's known as willful blindness. In other words, the concept that if you deliberately look away and deliberately don't make sure that you're not conscious of employee misconduct, the fact that you can be held liable for that knowledge anyway. Then we'll talk about minimizing risks of reporting employee misconduct. And finally, we want to just emphasize that this is an evolving area of the law, and it's also a very fact-specific area of the law. So before making any decisions about reporting employee misconduct, and certainly before making any decisions where there's already an investigation underway, make sure that you talk to a lawyer in the jurisdiction that you're in so that you're getting the best up-to-date legal advice.
Okay, so the first topic we are going to talk about is child sexual abuse material. And we're going a little bit too fast. And I want to be clear, we're not going to refer to that as child pornography. I'm going to read what Interpol said about why that term should not be used. A sexual image of a child is abuse or exploitation and should never be described as pornography. Pornography is a term that is used for adults engaging in consensual sexual acts to the general public for their sexual pleasure. Child abuse images are not. They involve children who cannot, would not consent, and are victims of a crime. The child abuse images are documented evidence of a crime in progress, a child being sexually abused. So as such, we are going to use the term child sexual abuse material, and we're going to talk about the obligation to report on the use of your computers or your equipment in any way to download, view, distribute, you're going too fast, child sexual abuse material. And the obligation to report an employee's use of a company's computers for child sexual abuse material does exist, although the full scope of that obligation is somewhat unclear. But for obvious legal and frankly ethical reasons, and we're going to talk about a case that really gets into this, you should report the use of your computers. We're also going to talk about ways to minimize the risks that your computers are used for this purpose.
So 18 U.S.C. 2258A is the statute in question, and this requires that in certain circumstances, people report child sexual abuse material. And it was designed to combat the online sexual exploitation of children. And what the statute says is that electronic communication service providers or remote service providers are required to report child pornography to the cyber tip line. So the question then becomes, what is an electronic communication service provider?
Okay, so an electronic communication service provider, and we put this on the screen, is any service which provides to users the ability to send or receive wire or electronic communications. But what does that mean? If you are an ECSP, you must report. But what does it mean to be an ECSP? We're going to talk about that. And if you are an ECSP, the penalty for failing to report, for knowingly and willingly failing to report, is quite steep. It's up to $150,000 for the first violation and up to $300,000 for each subsequent violation.
So ECSPs are definitely internet service providers like AOL, Verizon, et cetera. And we've put up on the screen a couple of cases that have explicitly held that they are. And similarly, ECSPs are social network companies like Facebook. And again, we've put up some cases. But the question is, how much further does it go?
Okay, so an ECSP, we believe, may be an employer, and we're going to explain why, if the employer provides email access to employees. And the case that discusses this is a case called Hatley v. Watts, which is a really crazy case. Mark, do you want to talk about the facts of that case and how this came about?
So Hatley v. Watts is a very strange case. It involves a love, not even a love triangle, but sort of a fake love quadrangle. Hatley and a woman named Nicole, whose last name is never actually given in the case. Hatley and Nicole are in a long-term relationship. Nicole then cheats on Hatley with Watts. And one of the things she tries to do is to convince Watts that Hatley is in fact cheating with Watts's wife. And as her way of trying to prove this, she convinces Watts to hack into Hatley's Blue Ridge Community College email service by giving him Hatley's password. Watts does hack into the system, and Hatley then sues Watts for breaking into his email service. And one of the questions before the court was, that statute, like the statute we're dealing with on child sexual abuse material, only applied to electronic communication service providers. And so the question was Blue Ridge Community College an electronic communication service provider?
And so one of the issues in the case was, were they a provider, or were they a pass-through, and was Gmail the provider? And the court said, no, you are the provider. You're providing email access to all these students. You are the provider. And so it stands to reason that, look, that's one case in the Fourth Circuit. There's not a lot of law on this, but it stands to reason that if the college is a provider, then by the same logic, an employer could be a provider.
In addition to the federal statute, which, as we said, we think means that you do need to report child sexual abuse material if it's being used on your employees' computers, there may be a common law duty to report this as well. And there's a case out there called Doe v. XYC Corporation, which again has a very troubling fact pattern. Do you want to talk about this a little, Leslie?
Yeah, so this case, which really should be called What Not to Do, involves this corporation, XYZ Corporation. It's a horrible fact pattern. Essentially, the corporation had on its email, when employees signed in, as you should have, they had the notice that this is not private. Everything you do on this computer belongs to the company. Nonetheless, they had an employee who was using the computers not just to download porn, but he was actually abusing his stepdaughter and uploading the images at work. And there were several red flags. Several people at this company said, hey, this guy's going to bad sites. We need to track it. Several people in IT said, let us track it. Let us do an audit trail, all the things that you're supposed to do. And the head of IT said, no, you can't do that. He's got a privacy right. And the court came back and said, that's crazy. He doesn't have a privacy right. He was committing a crime. It could have been stopped. The mother of the child he was abusing sued, and the court said she's absolutely right. It could have been stopped. The company needed to take basic steps. And we're going to, later on in the lecture, we're going to talk about things that you can do, basic steps that you can and should take as an employer. So there's no general duty to monitor everything that your employees do, but there is every reason that you should monitor for crimes. There are basic steps that you can take that are simple. And let's go through those now.
So first, there should be an equipment policy. You should have a written policy that all employer-issued equipment remains the employer's property, that employees have no privacy rights regarding the employer's equipment, that the employer has the right to access and search equipment at any time and without notice. And there should be automatic policy reminders about this. In other words, every time you log into the company's network, there should be a pop-up that reminds employers that there's no reminds employees that there's no privacy right. And this has a couple of benefits that we want to talk about. First off, it eliminates exactly the privacy violation concerns that came up in Doe v. XYC Corporation. In other words, you're not going to have an issue with an employee saying, hey, wait a minute, you had no right to be looking at my computer. But second of all, it deters bad behavior. When employees know that you're going to be looking at their computers, it means that they're less likely to use those computers for improper purposes.
Okay, and there's some more steps that you can take as well. These are more proactive measures. you can and should block offensive websites. If there's no need for somebody in your organization to go to a website, you can block the websites. It's fairly easy to do. Especially, you can establish keyword searches to notify supervisors if people are searching for terms that are suspicious, and you can then audit their trail of where they've been. It's especially easy to do this because you can subscribe to services that will blacklist certain sites. And they keep up with the sites so that you don't have to. They add sites all the time to those lists. And then again, you should conduct periodic audits of your employees' internet use, which is what the people in the IT department wanted to do in the XYZ case, and they were told not to, but you should conduct periodic audits. And that brings us to the end of this section.
Oops.
Before we move on
Oh.
to the next section.
Giving you too much of a quick
Mark's
preview,
a little
sorry.
trigger happy there. Sorry, he's little trigger happy. But before we move on, do we have anything else to add on the child sex abuse material?
I think the answer is that although the law itself is a little bit ambiguous, there's just every ethical reason and every good best practice reason, and frankly, the courts we're fairly convinced, interpret that ambiguous law in the pro-disclosure way. You should really take some steps to monitor employee equipment, and where employees are using child sexual abuse material, you need to report that to the cyber tip line immediately.
Yeah. Okay, so we're now going to move on to discuss SEC violations.
Okay, so there is also a duty or a best practice, let's say, under the Securities and Exchange Act of 1934 to report employee misconduct where there are SEC violations. And the common violations are pretty familiar to everybody here, but let me just run through them just quickly in case anybody isn't familiar. Common violations include misrepresentation or omission of important securities information, manipulation of securities market price, stealing customers' funds and securities, violating broker-dealers' fair treatment of customers, insider trading, selling unregistered securities. And finally, it's worth pointing out that whistleblowers are explicitly protected by the Act, and in fact, have been awarded $400 million in awards for blowing the whistle when these kinds of violations have occurred and not been reported properly.
Okay, so there is no express rule. Oop, what just happened? I don't know what just happened. All right, hopefully it's okay on your end. You guys can see this okay. Okay.
Oh, our clicker just stopped working.
Our clicker just stopped, Scott.
Oh, there we go, working again.
There's no express rule requiring reporting of employee misconduct vis-a-vis the SEC. Oh, apologies, our clicker. Okay. But there are several rules suggesting, Scott, this is actually point by point, suggesting reporting, especially for broker-dealers. So the SEC guidance in this is pretty clear. There's an obligation to supervise employees, and supervisors can be held liable for failing to do so. So from that, while it doesn't specifically require reporting to the SEC, it's hard to read this guidance without assuming that in some circumstances, in certain circumstances, reporting would be expected. And having spent many years at various law enforcement agencies, we certainly both read it that way.
Next slide.
Next slide,
For some
please.
reason, the clicker is refusing to reload. So reporting SEC violations. There are, thanks very much for letting that up. Even if the actual obligation to report is in some cases ambiguous, there are huge benefits to reporting, even when the benefit is ambiguous. And we want to run through some of those with you now. Next slide, please.
So in a document called the Seaboard Report, the SEC functionally codifies the benefits of self-reporting. And we're going to discuss that, the Seaboard report in some detail.
Next slide, please. So Seaboard was a farming company that owned, among other things, Chestnut Hills Farms. And the controller of Chestnut Hills Farms was Gisela de Leon Meredith. Next slide. And between 1995 and 2000, de Leon Meredith was overstating the assets and understating the expenses at Chestnut Hills Farms. There was an internal audit that was finished in 2000 that determined that she was in fact doing this. And she confessed to the crime. And as a result, the Seaboard, the parent company, hired an outside law firm to do a full, thorough investigation and fired Meredith and 2 supervisors. Next slide, please.
Okay, so immediately after firing Meredith, Seaboard disclosed to the public and to the SEC that they were going to, and they stated they were going to restate their financial statements. And they pledged complete cooperation with the SEC, including providing the details of their internal investigation without claiming any legal privileges or protections. And they promised to strengthen their financial reporting processes. And I'm just going to read a little bit about what that involved in terms of the financial reporting process. They developed a completely new process for dealing with the subsidiaries, because it was a subsidiary that got them in trouble here. And they consolidated subsidiary accounting functions under the parent company. They hired multiple new CPAs for the accounting department. They redesigned the subsidiary's minimum annual audit requirements, and they required the parent company's controller to interview and approve all senior accounting personnel in the subsidiary. So essentially, they took all of the accounting and they put it very specifically under the parent company. And because of all of those actions, the SEC took no enforcement action.
And in taking no enforcement action, they listed 4 reasons for why they didn't take an enforcement action. And this has become sort of the codification of the SEC's thinking in the matter. First, they said that the company engaged in self-policing prior to the misconduct's discovery. In other words, they did that. There was an effective compliance and procedures in tone. They had done that audit that, in fact, uncovered de Leon's misconduct. 2, they self-reported the misconduct as soon as it was discovered. 3, and did a thorough review and prompt disclosure. 3, there was remediation of the misconduct. They fired and disciplined the wrongdoers. They improved internal controls. They compensated adversely impacted parties. And finally, they fully cooperated with the authorities. As we mentioned, they didn't even withhold privileged material.
Okay, and they also discussed a number of other criteria that they would look to in determining whether to hold a company accountable. Okay, so I'm going to go through those with you. The nature of the misconduct, the way in which the misconduct arose, the where in the organization the misconduct occurred, how long the misconduct lasted, the amount of harm inflicted upon investors and other constituencies, how the misconduct was detected, who uncovered the misconduct, the time from discovery until effective response was implemented, the steps taken upon learning of the misconduct, the company's process for resolving issues and uncovering relevant information, and the thoroughness of the company's review, and the promptness of providing this review and sufficient documentation of its response to SEC. So all of those are factors that the SEC said they would take into account in determining who to charge and whether to charge the company itself, whether as opposed to just certain individuals.
So with that, we want to talk about a couple of examples of benefits of cooperating with the SEC, where essentially by cooperating with the SEC, the parent company itself was able to avoid significant consequences, even though their employees engage in misconduct.
Okay, so we're going to talk about some cases. So the first case we want to talk about is Credit Suisse. In 2012, the SEC charged 4 Credit Suisse employees with fraudulently inflating prices of $3 billion in subprime bonds. They completely ignored market information. It was completely made up. And instead, they priced these bonds to achieve fictional profits. They directed their traders to change the bond prices to hit the targets, cover up losses in the books, and send false profitability messages to senior management. Next slide, please.
Now, the SEC's Director of Enforcement, and I want to read this because they took a very, very harsh tone with these violations, as well they should have. Quote, at precisely the moment investors and market participants were urgently seeking accurate information about the financial institution's exposure to the subprime market, the senior bankers falsely and selfishly inflated the value of more than $3 billion in asset-backed securities in order to protect their bonuses and, in one case, protect a highly coveted promotion. Despite that really strong language, however, because Credit Suisse immediately reported to the SEC did not charge Credit Suisse itself with any crime or violation. Next slide, please.
Okay, another two cases that illustrate the benefits of cooperation are Akami Technologies and Nortech. Both of these companies' employees bribed Chinese officials for preferential treatment, relaxed oversight, reduced duties, taxes, or fees. And the bribes were substantial. They included cash, gift cards, meals, travel, entertainment. These were massive bribes. But the companies themselves immediately reported to the SEC, and SEC announced non-prosecution agreements with both companies.
On the other hand, on the flip side of this, there is a real cost to not cooperating with the SEC and to failing to report employee misconduct when it comes to the SEC. And we want to talk about one cautionary tale, to quote the SEC, and we'll get to that, called AgFeed USA.
So AgFeed, as you might be able to tell from the name, was an animal feed company. And they were charged with a fraudulent accounting scheme that propped up their stock price by inflating revenue by $239 million with fake invoices for sale of hogs and feed. And their scheme boosted annual revenue between 71 and 103% over three and a half years. And the SEC obviously charged the employees who committed the fraud. But in addition to that, they charged the company executive, and in particular, a director who was supposed to be the audit committee chair, because those people covered it up. So they charged them with attempting to avoid or delay disclosure once they learned of it.
And the SEC, and again, I want to quote what the SEC's Director of Enforcement said when announcing the charges. Quote, AgFeed's accounting misdeeds started in China, and the U.S. executives failed to properly investigate and disclose them to investors. This is a cautionary tale of what happens when an audit committee chair fails to perform his gatekeeper function in the face of massive red flags. That's really strong language. What do you think about that?
Yeah, I mean, clearly the SEC was very angry when, if a company, it's one thing if a couple of employees, if you have some rogue employees, but if you cover up or you don't come forward with the information, that's where your company is really going to get slammed by the full force of law enforcement. And that's true across the board, right? This is our last SEC slide. We're about to go on to another regulatory body, but I think this holds across the board.
Yeah, absolutely. And the phrase cautionary tale was, I think, put in there deliberately as a warning that the SEC is really going to take this seriously. I think people should always keep that phrase cautionary tale ringing in their ears.
And remember that for any prosecutory body, any regulatory body, they will always look to get the most culpable person, meaning the person the highest on the chain.
Right.
So to the extent that people higher up know about something and take no action to rectify it, those are always going to be your targets, right? I mean, you're never going to just get the low-level employees. You're always going to look to see what's the culture. How do we prevent this from happening, either in this company or somewhere else?
Absolutely. No, I think that's absolutely right.
So all of this stuff, we're giving it to you in the context of SEC, but this is really true across the board.
Yeah, absolutely. And so let's now talk about another institution.
Okay, another regulatory agency that I'm sure you're all familiar with, the Financial Industry Regulatory Authority, or FINRA. So FINRA members must report only certain violations to FINRA. And this is coming out of Rule 4530. Want to help me out with these?
Sure. So you must report, so you don't have to hear just one of us, you must report several issues, including a violation of securities, insurance, commodities, financial, investment related laws, rules, regulations, or standards of conduct. And there's FAQs by FINRA that clarify exactly when you do need to make this reporting. And we'll put those up on the screen. We're not going to read through all of them for you, but we'll put them up for you.
But one thing we did want to talk to you about is that you have to report within 30 days after your firm has concluded or reasonably should have concluded that a violation occurred. That's important because it means that you can take the time, if you are doing a diligent investigation, you can take the time to determine whether a violation has occurred. You can't obviously use that to hide behind.
Yeah, exactly. You get some time to do an investigation, but you can't sort of pretend that you reasonably couldn't have concluded this by stretching your investigation out. Do your investigation quickly, thoroughly, and then make a decision. Next slide, please. So there are serious sanctions for failing to report under FINRA Rule 4530, and these include the following. We'll put them up on the screen for you, please. Fines of $5,000 to $146,000, disgorgement of any gains, suspension of the responsible principal in all supervisory capacities for 10 to 30 business days, the firm's membership suspension until the deficiencies are corrected, suspension of the responsible principal for 2 years, and a bar on the principal in all supervisory capacities. So failing to report to FINRA has some real consequences. Next slide.
But, and again, this is going to be the same across every regulatory agency and every office, really. A firm can receive reduced sanctions by doing the right thing. So by one, self-reporting violations with detailed account and offering to provide additional explanations, documents, and witnesses. So again, this is the same as we were talking about SEC. If you provide information to the regulatory body, that will benefit you. 2, taking extraordinary actions to correct deficiencies and provide customers with remedies. Of course, one of the main issues is how are you going to prevent this from happening in the future? And how are you going to make people whole? And 3, providing substantial assistance to FINRA investigations. And now we're going to move on to another topic.
So let's now talk about yet another topic, which is wage and hour reporting violations. So the Fair Labor Standards Act has severe penalties for failing to pay overtime and minimum wage under a variety of circumstances. And there are really serious penalties. The question becomes, at what point are you obligated to report wage and hour violations if some employees are essentially not paying lower level employees their overtime or required minimum wage violations? Next slide, please.
So normally wrongdoing with regards to wage and hour violations is discovered one of 2 ways. Either Labor Department investigators are doing an investigation and they find out about this when they're looking, either for some reason they're looking at the company, they find out about this, or there's an employee whistleblower. And by the way, whistleblowers are protected under the Fair Labor Standards Act from retaliation. But there are occasions when employers discover this through their own self-audits, particularly if you have a large company. This could be the case that you discover it yourself. And the question becomes what to do if it is discovered.
Well, the Department of Labor has something called the Payroll Audit Independent Determination, or PAID program. And this facilitates resolution of some potential overtime and minimum wage violations under the Fair Labor Standards Act. The question is, do you want to participate in the PAID program? But first, let's talk about the program's objectives.
Okay, so the PAID program has 3 basic objectives. To resolve claims expeditiously and without litigation, to improve employers' compliance with overtime and minimum wage obligations, and to ensure that more employees get their back wages owed more quickly.
Now, under the PAID program, Employers will audit their compensation practices for potentially non-compliant practices. And if you discover any of these and you want to resolve it, you've got to do the following things. One, you've got to specifically identify the potential violations, the employees who are affected, the timeframes for each affected employee, and then you calculate the back wages the employer believes owed to each employee. And that's what the paid program requires.
Okay, so back to our question of should employers participate in the paid program? It depends. It's a balancing act. You have to determine, on the one hand, participation may eliminate the risk of double damages and costly litigation. So that's a huge benefit. But on the other hand, it might subject you to a broader investigation than anticipated or follow-up investigation. So that's not a very satisfactory answer. But before we move on to our next topic, do you want to say anything else about the paid program?
Yeah, and remember, the paid program also is not going to cover state investigations. So if you're not paying appropriate minimum wage, you may have both federal and state violations. And the paid program is only going to deal with your federal obligations. You could still be leaving yourself subject to a state investigation. So really, I would say before deciding whether to join the paid program, because it's so fact specific, you really need to talk with a lawyer in the jurisdiction you're in to figure out whether balancing these two competing interests makes sense for you to join the program.
Well, you should be aware the program exists.
Yeah, absolutely.
Okay. All right, and now we're going to move on to our next topic.
So the next topic is workplace violence, and what to do if you become aware that one employee has engaged in either violence or threats of violence against another employee. Now, the Occupational Safety and Health Administration has a general duty and guidelines clause, and that it's section 5A1A of the general duty clause. And it requires that employers provide employees with a place of employment that, quote, is free from recognized hazards that are causing or are likely to cause death or serious physical harm. So that's the basic OSHA obligation.
So what do we normally think of as an OSHA violation? Let's play.
Okay, now that we've looked at the wrong way to think about OSHA, let's talk about the right way to think about it. Although OSHA does not have an explicit provision requiring that employers report workplace violent incidents to law enforcement, OSHA has a series of best practices that we're going to review with you right now because we think they're very important for you to understand. And there's really no, I think, Leslie, you'd agree, there's no good way to read those best practices as anything other than an obligation to report workplace violence when it occurs.
And I think there's a lot of things you can do in advance to monitor, make sure that your workplace is safe. So let's go through the best practices. We're just going to run through these. Okay, so somebody in your organization needs to be assigned the responsibility and authority for all aspects of a workplace violence prevention program. And they need to be assigned a responsibility for ensuring that all managers and supervisors know their obligations. So you've got to have a policy and you've got to train on that policy. And you need to maintain a system of accountability for managers, supervisors, and workers. You need to establish policies to ensure that there is reporting, recording, and monitoring of all incidents of violence, if they do occur, and all near misses, and that no reprisals are made against anyone who reports something in good faith. And you need to determine in advance who to notify both within the organization and outside when there is an incident. So all of that, we're going to talk a little bit more about best practices, but you need to have your practices, you need to have them in writing, you need to be training on them.
Right. A few more best practices from OSHA. You need to understand which incidents must be reported and what information must be included. You need to develop a standard response action plan for violent situations, including the availability of assistance, alarm system response, and communication procedures. Employers should evaluate these safety and security measures on a regular basis. This includes top management regularly reviewing the program with each incident to evaluate its success. It also includes having responsible parties, which includes managers, supervisors, and employees, reevaluating policies and procedures in light of what's gone on.
So, needless to say, if an inspector learns about workplace violence, they'll report it, but you should have a process in place to self-report these incidents. And essentially what we're saying here is that OSHA involves more than what you think it involves. It does involve, basic safety in terms of your building and all of that, but it also involves keeping your workers safe from workplace violence. So you need to take a broad view of what workplace safety means. It doesn't just mean that people aren't breathing in asbestos. It's broader than that.
Right, I think that's exactly right. Workplace violence is very much part of what OSHA considers to be safety. And when you look at OSHA's best practices, it's clear that they expect, and I think Leslie and I, as former regulators, would say we would expect reading these, that you do report employee misconduct in this area as well.
Right. And so those are the big, we've now gone through the major federal statutes. And now we're going to move on to discussing state reporting requirements.
So there are a couple of states, not many, but a couple of states that actually require corporations or individuals to report crimes. And we'll put up on the board 2 states that do that, Colorado and Texas. And so you should always consult with counsel in your local jurisdiction, because in some states, a company may have a state obligation to report crimes by their employees.
Yeah, it's interesting. I mean, Colorado, I think, has got to be the broadest. Have you ever seen anything like that? It's
no.
much broader than what we have in New York. The duty of every corporation or person who has reasonable grounds to believe a crime has been committed, you have a duty to report. That's about as broad as it gets.
Yeah,
and that's unusual.
That's very broad, and it's not something that I've seen in a lot of other states particularly, and it's much broader than what we have here in New York.
But it's worth knowing what the obligations are in your state.
Absolutely.
And next slide, please. So we're going to talk a little bit about New York, because that's where we practice. And New York doesn't have a general reporting requirement. But what's interesting about New York's reporting requirement is it is based solely and exclusively on the desire to find and fight child abuse. So our reporting requirements in New York, we have certain individuals, and they are actually just the individuals who will come in contact with children, and they are required to report. So it's doctors, pediatricians, teachers, law enforcement. So every state is different. For those of us who've been in New York for a while, we're just used to this as the norm, but
Right.
You should figure out what the state requirements are for reporting.
Right. I mean, I think the lesson here is that different states have different requirements, and they can be wildly divergent. So make sure that you're checking with local counsel in the jurisdiction that you're in. Let's move on to another topic, which is willful blindness. And willful blindness basically occurs, and it's a doctrine. Willful blindness occurs where you deliberately look away and deliberately avoid learning about employee misconduct. And where that occurs, the willful blindness doctrine will impute to you the knowledge that you deliberately didn't learn and treat you as though you did have that knowledge. And this is true in both criminal and civil contexts. Next slide, please.
So again, you can't just, if you have reason to suspect a problem but intentionally look away, you can be held criminally liable. So you cannot avoid criminal liability simply by, like the last slide, covering your eyes and covering your ears. That's not going to work. Next part of this slide, please. There we go. So that's the criminal liability statute.
And the next slide, please. That's the case. That's one case that we're putting up, on the willful, but there's plenty of others. Next slide, please. The civil context is basically the same as the criminal context. And we've put up on the screen a quote from at least one case dealing with willful blindness. But the bottom line is, if you deliberately look away, you're going to be imputed and charged with the knowledge. And to make sure that nobody thinks you're deliberately looking away, it's important to have internal controls in place at the outset. And we're going to talk a little bit more about that before we finish up the hour. Next slide.
Okay, so we really can't, I don't think we can stress this enough, that the best way to protect yourself is to have an internal compliance program, a robust internal compliance program. So we're going to talk about some aspects of that program. So you need to develop a robust compliance program, as I just said, to prevent and detect violations of regulations and laws. This is true even if you have a small company. The compliance program can be scaled, but you shouldn't think that just because you have a smaller company, you shouldn't have any program in place. So you need to have a program to assess and address your company's risks, and you should designate at a minimum a compliance officer. If you have a larger company, possibly a compliance committee. And you need to have written policies, procedures, and standards of conduct. This is basic. It's important. We just drafted this for somebody recently. Everybody should have an employee handbook, and everybody should be trained on the handbook and educated about what the procedures are and what the standards of conduct are.
Next slide, please. Some other things that you should do to minimize the risks that we've been talking about for the last 40 minutes or so. You should develop a means to report violations to a compliance officer or compliance committee. You should have a clear policy precluding retaliation for reporting. That's really, really important. You want people to feel safe reporting misconduct. You should conduct internal monitoring and auditing of compliance with policies, procedures, and standards of conduct. You should enforce the policies. And in other words, it's no good to have a bunch of policies and not enforce them. You need to enforce the policy that you have and you need to have publicized disciplinary guidelines. And finally, make sure that you have due process for protections for the suspected wrongdoers. And the reason for the due process is, it provides some protection if the reported employee is going to ultimately object to their treatment. You want to be able to say, look, we treated you fairly. And finally, make sure that you respond promptly to detected offenses and take corrective action promptly.
Okay, and you want to have an employee code of conduct. There's 3 reasons why you want to have that. Very important. It increases the likelihood of proper conduct. It puts the employees on notice, so it reduces reported employee claims. And if misconduct occurs, you can demonstrate that efforts were taken to prevent it. Do you have anything you want to add to that?
I think that third point is really important. If something goes wrong and you end up having to report employee misconduct, you want to be able to show, and this was one of the factors in the Seaboard report for the SEC, and it's a factor, and it's, I think, Leslie, you and I have seen this a million times when we've done investigations. If you have an employee code of conduct, you can show, look, we tried to prevent this misconduct. We weren't lax with our procedures. And that goes a long way with many regulatory agencies.
Right.
Let's just a little bit of guidance for in-house and outside counsel on reporting to authorities. The first, and I can't stress this enough, be forthright and honest. The only thing you have going for you when you report to the authorities or when you're dealing with a regulator who's beginning to investigate is your good word and your reputation for truthfulness. And once you lose that, it becomes almost impossible to deal on any kind of even playing field with a regulatory authority. Make sure you preserve all documents, both written and electronic. Now, if you know there's an investigation going on, have your attorney contact the investigating agency to gauge the investigation's scope. And finally, if it's necessary, if you know that you're under investigation, make sure you hire outside counsel with experience dealing with investigations and dealing with the agencies in question. This is not the time to be sort of making it up as you go along. And it's not the time to be doing it just internally.
Okay, so the final point is that clearly reporting on employee conduct does come with some risks. There is a risk of defamation claims and discrimination claims. So what can you do to decrease that risk? First, conduct a very thorough investigation. Sometimes that can be done in-house, depending on your situation. Sometimes you need outside counsel. And you should consider hiring experts. For example, if it's a financial investigation, consider hiring an accounting firm. There are certainly a lot of firms that specialize in these type of internal investigations, or consider having your counsel hire the accounting firm to preserve attorney-client privilege. Immediately preserve all your documents. So you need to send a preservation notice to everyone who might have a document, telling them not to destroy that. You need to set up a system for preserving all of the paper and electronic documents. And of course, maintain a paper trail and prepare a thorough investigation memo detailing exactly what actions you've taken.
Absolutely. And that finishes up what we wanted to talk about. I see there's a couple minutes left.
Are there questions? I don't know how to see if there are questions, but
if there are questions, we're happy to take them.
Okay, guys. Yeah, I do not see any questions. Want to thank Leslie and you guys. If we do get questions, I know we're covering a lot of material. We will certainly forward them to you and connect Mark and Leslie to anyone, which is great. So it is an honor and a privilege to introduce our next speaker, who actually spoke last year and was requested again, because a lot of people do have questions on how to get in front of the Supreme Court. I think we still have audio from Leslie and Mark coming through. Some people may be hearing both at this point. The path to doing this may be a little bit broader. And so in this session, Justice Melody Stewart is going to give an overview of matters that come before the court, but also focus on how you can get in front of the court and then some of the other things, including disciplinary matters. Justice Stewart was elected in 2018 to a full term as the 161st Justice to serve on the court. I should say that a lot of what we're talking about in Ohio would be applicable to the other states. We do have people from Illinois, Florida, New York, and a couple other states joining us. Prior to joining the Supreme Court, Justice Stewart served on the 8th District Court of Appeals. She was elected to an unexpired term in 2006, and then twice reelected. Of historical note, Justice Stewart is the first African-American woman elected to the Ohio Supreme Court. And she has a very interesting background. Besides 30 years of combined administrative, legal, and academic experience, she was the administrator for a healthcare management company, a music teacher, a civil defense litigator, and also a law school administrator and professor before joining the Court of Appeals. So after practicing law as an assistant law director for CESA Cleveland in East Cleveland, she worked as a lecturer, adjunct professor, and then assistant dean at Cleveland Marshall before becoming full-time. So Justice Stewart actually earned a bachelor degree from the College Conservatory of Music at the University of Cincinnati. Her law degree is from Cleveland Marshall Law School at Cleveland State University, and she has a PhD as a Mandel Leadership Fellow from Case Western. She also has an honorary degree of laws from Cleveland State. So with that, it's truly an honor and a privilege to introduce Justice Stewart, our last speaker of today.
Thank you, Randy. Good afternoon to everyone. I'd love to say, Randy, save the best for last, but I'm probably just the obstacle between you and lunch. But thanks everybody for having me. I will try to make this not be so dry as possible, but I think everything that is Supreme Court is interesting. So we're ad-libbing a bit now because I can't control my clicker, so you'll have to forgive me when you hear me say. Next slide. Okay, let's start off with an overview of the court. you know, when most people think about the Supreme Court, they of course think about appellate review in the court, and that is primarily what the court does. However, we are a court of original jurisdiction also in cases of for extraordinary writs, writs of mandamus, writs of procedendo, quo warranto, prohibition, and we'll talk a little bit more about those later. You can imagine how busy the Supreme Court was from March of this year up into approximately 90 days before the general election. That's the time where we get a lot of writs filed for election complaints. So when the state of Ohio shut down essentially on March 17th, the night before the primary election, we had a writ filed in the court that day at approximately 9 or 10 o'clock at night. And yes, we were up until 3 that morning to render a judgment on that decision. So those are original actions that do come into the court. Then, of course, the court has a regulating body, oversight, bar admissions, continuing legal education, disciplinary actions. So the rules of superintendents for the bench and the bar. And then, of course, the court, we promulgate rules with the assistance of committees and commissions. Next slide. So we'll look at these each a little more closely. For appellate review, there are essentially 5 types of appellate decisions or decisions that we review on appeal at the court. The first is appeal as a matter of right. That involves death penalty cases. It used to be that those cases were appealed from the trial court to the Court of Appeals and then to the Supreme Court. The Court of Appeals has been cut out of the process. So we get direct appeals in death penalty cases. And the Court of Appeals also has jurisdiction for extraordinary writs. And so we review those decisions. If you're a party that doesn't like the decision of the appellate court on an original action, those come to us as a direct appeal as a matter of right. Election contests that we talked about too, when those contests are in the appellate court. And then appeals from orders denying DNA testing under 2953 of the statute. Second type of appellate review cases are certified conflicts. Those cases deal with a decision from one of our district appellate courts that conflicts in law with a decision of another appellate district. Next slide, please. Also, we direct appeals from certified questions from the federal courts come to us directly, and appeals from certain administrative agencies, the Board of Tax Appeals, the Public Utilities Commission. And then, last but not least, the group of appeals we'll talk most about for this presentation today are jurisdictional appeals. Those are appeals that are always lined up at the on the front steps of the courthouse trying to get in. These are appeals where we exercise jurisdiction to take them in, when they are issues of great or public interest, when they are involving substantial constitutional questions, and where the decision will have a great impact on the community in general. So we'll get into those a little more detail also. Next, please. So your appeals as of right, again, extraordinary writs, writs of mandamus, writs of procedendo, writs of habeas corpus, writs of quo warranto, contempt proceedings out of the Court of Appeals, death penalty cases, and then the DNA. Those, again, our appeals are a matter of right. We don't get to throw you out unless you're have them filed in the requisite time. Next slide. Certified questions of law from the appellate court. This is interesting in that, again, they have to be conflicts of questions of law, not in how the courts interpreted the case, not if the facts are so fact specific from a case out of, say, the 11th district versus a case out of the 10th district or the 12th district. And the certifying body has to be the appellate court. So the Supreme Court can't certify the conflict. The appellate court has to do so. it can do so sua sponte on its own, or one or both of the parties can ask the appellate court to certify the conflict to the Supreme Court. If the appellate court does make the certification, then it is, of course, up to the party who wants that conflict certified to then follow through with the appeal. Conflicts that come to back up to on the certified conflicts from the appellate court. If we get a certified conflict, and in the time that we are reviewing the conflict, we later decide that we improvidently accepted it, we can decertify it, or we can dismiss the case as improperly certified. Questions, certifications from the appellate, from the federal courts. Next slide, please. From the federal courts is similar. That's where a federal court can ask the Supreme Court to clarify a certain legal premise from state law that it is either not clear or the Supreme Court hasn't passed on it, and the federal court needs our court's decision in order to move forward with its case. And it's not mandatory for the federal court to do that. And unlike the certifications that come from the Court of Appeals, the Supreme Court can decide not to accept the certification from the federal court. Next slide. From administrative agencies, again, those appeals come directly from us, from the Board of the Public Utilities Commission. Also, there are certain appeals from the Bureaus of Workers' Compensation that come directly to the Supreme Court. And we have, there's a statute that says only the Supreme Court can vacate, set aside, reverse, correct, or amend any order from the Bureau of Workers' Compensation. Next slide. Jurisdictional appeals. So these are the ones, last but not least for our appellate review, appeals which primarily focus on we have to grant leave. We average about, I'd say anywhere from 30, we review 30 to 50 jurisdictional requests for jurisdictional appeals, probably every other week. If we review, say, 50, we may grant 2, sometimes 3, sometimes we grant none. And so the vast majority of petitions to get in on jurisdictional appeal are not accepted. And again, there has to be a substantial question, a substantial constitutional question, a substantial statutory interpretation question. It has to be of great importance and significance to the state or to parties, or could have wide-ranging implications in the case. It can't just be you don't like the decision of the appellate court, or it has a negative impact on your client. And ironically too, and most people hate this, but it is not error correction. So there might be a time where we look at an appellate court decision and say, yeah, I think the Court of Appeals got that one wrong. And unfortunately, sometimes it's to the detriment of your client, but we are not an error correcting court. So we won't take it to just correct the Court of Appeals such that the decision is right for you or right for your client. The jurisdictional appeal is set forth by propositions of law, and those are sometimes the lawyer's best day, because depending on how you frame the propositions of law, usually will determine whether it gets into the court. And lawyers, unfortunately, a lot of lawyers don't recognize that and form their propositions of law as if they were assignments of error, like people similarly do at the Court of Appeals level. And that doesn't work for jurisdictional appeals. Did we go backwards or do we go forwards? That looks like let's go back one, just going forward. Okay. Yeah, thank you. Okay. So the original actions on appeals, just to talk briefly about those. Procedendo, prohibition, mandamus, habeas corpus, those get filed in our court, let's start with habeas corpus at the bottom one. If there's wrongful imprisonment or excessive bail, or someone alleges that they're entitled to release, again, for procedendo, when a lower court needs to proceed and it has not done so, maybe you've had a motion pending in the trial court for an extraordinary amount of time. You can file a writ of procedendo. We can order the court to rule. And oftentimes, we can order the court to rule and make a decision, but obviously we can't control what that decision is. We can't say, court, grant that motion. We can only say, court, rule on that motion. Mandamus, of course, is to make a public official do an act that is required of him or her. We often see those in the board for election filings, where someone wants the Board of Elections to put them on the ballot, or put an issue on the ballot, or certify some electors for some election matter. And then prohibiting a lower court from performing certain functions. And that's usually when a court does not have jurisdiction to do something that it's about to do, either because another court has divested that court of jurisdiction, or the court simply is not authorized to do it by statute, or because a superior decision has come into play, or the case is sitting in a superior court. Next slide, please. Regulation and oversight. It was very challenging for us this year with the bar examination. So we have a bar exam in Ohio, as you know, twice a year. And this year we went to the uniform bar examination. So we administered for this year, the first time, a virtual bar exam. And we moved the July bar exam to September, where we were going to have it live and in person. But then after the pandemic issues did not abate, we moved it to October and had our virtual bar exam then. So from bar admissions to disciplinary action to admissions without examinations, looking at the unauthorized practice of law, being lawyers who are not admitted to practice on Ohio, practicing in Ohio, or lawyers practicing under suspension, or people who are not lawyers at all practicing law. Of course, we administer and oversee your CLE requirements. And so all those kind of regulatory oversight things are the bailiwick, if you will, of the Supreme Court, again, with the assistance of our various divisions, department heads, committees, and commissions who are the initial, the front line of starting those processes. Next slide, please. Our rules of practice and procedure, as you know, all the rules that govern day-to-day life with lawyers, rules of appellate procedure, of evidence, of criminal procedure, the traffic rules, juvenile rules, etc. The Supreme Court, promulgates those rules of superintendence, Supreme Court practice. Some rules, of course, have to be done with the legislature and the General Assembly being partner to those. Others are just by Supreme Court promulgation. Next slide. Do we have any questions about that overview? And I would imagine that if you do have some, I don't know if I can hear you, whether they come up through chat, or maybe there's a time afterwards where we can address them. Okay, I'm told questions at the end. All right, next slide. So the meat of the presentation, as the title of the presentation offers. What constitutes a substantial question to get into the Supreme Court on a jurisdictional appeal? What's of great public interest? First of all, if you have a case coming out of the appellate court that's a split decision, that increases the chances of a case getting in on a jurisdictional appeal, as opposed to a decision that was unanimously decided. That's not to say that unanimous decisions from the appellate court don't get accepted for a jurisdictional appeal in the Supreme Court. They do. And sometimes we reverse a unanimous decision from an appellate court. And then, of course, too, sometimes we affirm those decisions. But again, the court is more inclined to accept some issue of law where the appellate courts have differed on the issue to address. Sometimes the court, in its decision, actually mentions that the Supreme Court has not really clarified this particular area of law, or the appellate courts are looking for guidance. Sometimes the trial courts also, because it's application of a newer statute or an amended statute. And so oftentimes the appellate court, as I recall doing, sitting on the Court of Appeals too, we will tickle the Supreme Court, if you will, to say, hey, it'd be nice if you took this case in or took these sort of cases in so that we wouldn't have to continue to guess on the direction we're supposed to go, particularly if the courts seem to be going different ways, but that don't necessarily present an actual certified conflict of law to come in. So again, the appellate court can often nudge the Supreme Court and when to take a case. The appellant, of course, trying to get in is the one that's got to put forth to us and make clear what the issue is. So often, I won't say so often, but there are times when a lawyer will frame the proposition of law to get into the court, only to squander that opportunity later on when getting there and briefing the case, because the appellate attorney defaults to the intermediate court of appeals mode of presenting the brief. And that is a squandered opportunity, because if the proposition of law in the jurisdictional appeal was set forth in a way that was of interest to 4 justices, at least 4, you got to get 4 of the 7, then there was something there. But we can't raise issues that you don't raise. And so if you get in, be sure to know how to phrase or categorize the jurisdictional appeal such that the proposition will be answered in the way you want the court to answer. Again, should the proposition is a simple statement of the law, and be sure not to be argumentative. You just want the court to set forth a rule of law, and it might just so happen to help your client. Next page, please. This is an example of a case we heard this year, or the proposition of law, where our holding actually mirrored the proposition of law. And that's a good sign that the proposition of law is a good one. Some of you might be familiar with the case, Brook Park versus Rotajev. In that case, the proposition actually stated was whether the results of any speed measuring device using radar or laser are admissible without expert testimony, establishing or taking the judicial notice of the scientific reliability of the principles underlying that technology. Many of you have probably represented clients or yourselves with traffic camera tickets and with using radar technology. You good lawyers want to have some expert come in and talk about the reliability of laser technology or the reliability of radar technology, in addition to having the police officer testify about whether the instrument was properly calibrated, whether the distance was apart, how much training the officer had. I mean, anything to get out of a traffic ticket, right? So that was a proposition of law stated to us. And we established once and for all that you don't need expert testimony to challenge, to have the reliability of laser or radar technology come in for speeding ticket. Now, I know many, of course, disagreed with that decision, but there were cogent arguments to say that this technology has been around forever. We don't ask people to have an expert come in to talk about the reliability of X-ray technology. I mean, at some point, the technology is widely enough accepted that we don't have to belabor the issue or expend unnecessary court time or litigant resources for that. So then the holding of the case, as you see, we held that the results of the measuring device using radar or laser are admissible without expert testimony or taking judicial notice. Now, if any of you read the case or familiar with the case, this does not absolve the state or the prosecution from challenging or doesn't absolve the state from bringing in evidence that shows that the police officer was properly trained in doing it, and all the other matters that make the issuance of the ticket still reliable and not against the manifest weight of the evidence, or that there was sufficient evidence to say that the citation was good. That case just dealt with the reliability of laser and radar technology, which of course impacts all radar and laser cameras across the state. All right, next slide. Okay, and when you're doing proposition of law in your appellate jurisdiction, you have to make sure that it's clean. Every now and then we will get cases that still have some dangling issue, either at the appellate court level and sometimes even at the trial court levels that were missed. A claim that was not disposed of, or there might be a motion pending in the trial in the appellate court. So procedurally, make sure that everything is clean when you're filing that petition, that proposition of law, or to get in the jurisdictional appeal, or else you've wasted time, you've wasted money, you've wasted filing fees. And make sure that every aspect of the record is available to us. When you file your jurisdictional, we don't get the record. It's really, you're letting us know what the record entails. But if you get in and then you don't have support for your propositions of law, then once again, you have wasted time, wasted energy, and your position obviously fails. Be sure to phrase your proposition of law in a way that makes it more global, that makes it more far-reaching, as opposed to the miscarriage of justice suffered by your client. Next slide. So let's look at a couple of cases where, again, jurisdiction examples that we've accepted for this year. State versus Weber is a case that may, since I saw the case number on it when I put this together, it's still pending, so it hasn't come out, which means, of course, I can tell you what the case says. It's been argued. You can watch the argument, but just to look at the interesting issue here. So in Weber, we have a case where a defendant was convicted of violating a statute prohibiting a firearm. Well, the statute expressly says that a person cannot handle or have, doesn't say use, but have a firearm while intoxicated. And this was a case where a wife called a police officer to a home where the husband was highly intoxicated and he had a shotgun. The police came. The person was, by the police officer's account from observation, highly intoxicated and was standing at the top of the stairs with a shotgun, but the gun was pointed down toward the ground. He somewhat stumbled down the stairs, told the police officers the gun was unloaded, and it was, but he was cited for violation of the statute. He argued, of course, that he has a right to have a gun in his home and that the statute violates the Second Amendment to his right to bear arms. So you can imagine that's going to have far-reaching implications, the decision that we make in that case. And you can, of course, imagine what the issues are. You've got the Second Amendment, but the Second Amendment isn't an amendment that can be applied without limitations. As we know, there have been statutory exceptions to the Second Amendment. Is the importance of one of them, does the legislature have an interest in being sure that people who are intoxicated don't handle firearms? Then, of course, there's an issue of, is there a difference between a firearm that's loaded and one that's unloaded? Well, of course, there's a difference between that. And should it matter that the defendant was in his home as opposed to outside on his front porch or walking along the sidewalk? So that you can understand or see the implications of that kind of case. Another one was one recently decided, because the slip opinion is there, which is the AJR versus Loop decision. And this is a case where parents sued a school district and teachers because their child was injured by another student. And I believe the students in this case were kindergartners or first graders. They're small kids. And their child had been bullied, and they reported it to the school, and the school had taken some actions and were aware of it. And then somewhat randomly, their child was injured when the child was poked by another student with a pencil. And so the parents alleged that the school and the teachers were reckless in their awareness of their child being bullied. And that is a question, of course, of whether the teachers, this was a public school system, whether the teachers should be immune from liability. Again, a case with far-reaching implications, and that case was decided, and the court determined that the teachers and the school system is immune from liability and that they did not act recklessly. Next slide. Athens versus McLean. That's a case where a group of cities in the state of Ohio argued that there's a violation of their home rule authority because the state has a central collection agency that really makes it easier for some businesses to pay their local taxes through the state. However, that allows the state to take a percentage of that amount, and a bunch of cities didn't like that, of course, and so they got together and they sued in that case. That is an opinion that has come out, and the court decided that the agency, the central collection agency, can do that, but they can't take part of the local city's taxes. Again, another case with far-reaching implications, and you can see how that goes. So one of the things I thought about with doing this was putting in some cases that don't get in, that didn't have far-reaching applications. But you can virtually imagine them. If any of you have filed any cases in the Court of Appeals on your assignments of error, they are very specific. In criminal cases, the trial court erred because the trial court convicted your criminal defendant on insufficient evidence, or the evidence was against the manifest weight of the evidence. Those cases will almost never get into the Supreme Court because it just then revolves review of what the appellate court did. And most of the time, again, unless there's some constitutional, some broad constitutional application, often those cases are quite the same. Sometimes in civil cases, it's challenges to the admission of evidence, of expert witness testimony, or the exclusion of some evidence. And again, those are individual calls made at the trial court, and if the appellate court reviews them with case law that supports that position, there often isn't much for us to say about them. Even if there are some conflicts in some courts admitting certain evidence while other courts did not, overall those are so case specific that they're likely not going to make it to the Supreme Court. Okay, another case we had, State versus Chapman. This was a very interesting case, and sometimes I have to admit, I'll read a jurisdictional and just say, this is just interesting because of the facts. So this was a case where someone had 11 children and was being prosecuted for failure to pay child support. You might need to have 11 jobs if you have 11 children, I'm just saying. But, and so part of the order the trial court put on for this failure to support was the person had to make attempts from fathering any more children until he's able to support the 11 that he has. Makes sense, right? The problem is, constitutionally, everybody has a right to have a child. Now, I can already hear some people saying, yeah, but the children have a right to be supported too. And that's absolutely right. The children do. That's why he was prosecuted for failure to pay support. But the question before us, of course, is, does that order making him to refrain? And it doesn't say, I forbid you to have children. The order said, try to from, producing any more children. And I'm not even sure how the court monitors that. I mean, obviously you can't have the person be sterilized. Does he have to file an affidavit to say, anytime that I have sexual encounters, I'm using some sort of birth control, or the woman's using birth control? Again, I don't even know how you monitor something like that. But the real crux of the issue is, can you do that? And so, did we decide that case? We have not yet, because actually, we probably have, but it hasn't been released. So it's got a case number. So that case might be something you look out for in the next several weeks coming out. Next slide, please. Lunsford versus Sterilite. I think we got a lot of press on this one. This decision has come out. So this is a case dealing with drug testing, which is prevalent in the private and the public sector. And this is a case where 4 employees sued their employer and the lab that the employer used to process urine specimens for drug testing. So the company had a drug testing policy. Everybody knew that the company had a drug testing policy, but somewhere along the line, the employer changed the policy from, hey, just provide a sample, and everybody knew they could be called randomly to do so. 4 employees were called randomly to do so. And the drug testing policy was such that you produce a specimen when asked, or within a certain amount of time, and the failure to do so for whatever reason, because you choose not to or because you can't, results in your termination of employment. So 4 employees were called to do this to submit a urine specimen, but the company had changed the policy and required the urine specimen be given under direct observation. So a representative for the lab used a same gendered lab tech to observe the genitalia of whoever was supposed to give a sample. 4 employees sued for invasion of privacy in that case. And so the court decided that because these employees were at will, that they had no expectation of privacy, that the General Assembly hasn't carved out such a cause of action in the revised code, and that these employees essentially consented to this direct observation method, even though it hadn't been the policy of the company, but consented to it because they didn't object at the time that they were told to give a specimen. Of course, objection would have meant termination, but so the majority found that there was consent to this. I just might add, there was a wonderful dissenting opinion written in that case, and I'll just leave that there. Okay, the next case. Phoenix Lighting. This is a case I'm sure a lot of you read because it dealt with attorney's fees. Again, another wide-reaching case because it deals with how trial courts calculate attorney's fees and whether there should be additional monies added on to attorney's fees when there's the winning side, or is the amount of time spent on the case, the hourly fee the attorney charges, the amount of time put in, the specialization of the case, are all those things already calculated into determining what's an appropriate attorney fee award, I should say, from the losing party to the winning party in a case. So the case was about tortious interference with a business relationship, and as you see there was the trial court awarded $4 million in attorney's fees. The majority in that case decided that the calculation was incorrect. The trial court essentially provided for compensation for attorney's fees on matters that had already been calculated. The time put forth in the case, the hours involved, the fact that some aspect of it might have been contingency. And Justice Fisher, too, I think wrote a nice concurring opinion in that case, too, to say that there are sometimes cases that should get the extra bump in money because of the ever-present value of money that is kept from the attorneys working on these cases for sometimes years at a time. So that's an opinion I think might be of interest to a lot of you. Next slide, please. Are we doing on time? Okay. I should stop saying that. Sherman versus Ohio OPERS. Oh, yes, this is a class action lawsuit that dealt with whether some employees who had retired but then were reemployed by the public employee system should have a reduced subsidy for their health benefits. So an employee, so the OPERS decided in a business decision that retired people who come back in the workforce don't have the same health care benefit as non-retired people. And in that case, there was an alleged violation of equal protection. And the court found that the trial court dismissed the case. And I might say, too, to go back talking about the trial court's disposition of a case, in the Lunsford versus Sterilite case dealing with the urine specimen test, that case was disposed of at the trial court level on a Rule 12 dismissal, and as opposed to getting to the case on the merits. And that was a split decision. That was a 4-3 decision, with the dissents saying that they have at least colorably stated a claim for invasion of privacy under the law of Ohio for invasion of privacy, so that at least survives. And whether or not there was an issue of consent is a question of material fact, such that it shouldn't be out on 12b-6. But again, so how cases are disposed of too are important to how the Court of Appeals considers them. Those dealing with issues of law are more ripe for review as opposed to once a jury has decided it. However, we have had cases where a jury has reached a verdict also that got appealed to the Court of Appeals and affirmed, and ultimately, due to the issue of law, the Supreme Court has still reversed based on how it's had to answer the proposition or propositions of law that has come before the court. Okay, final case in this example is State versus Kinney. For those of you who practice criminal law, you know that the Ohio Revised Code 295308 prohibits review of a sentence imposed for aggravated murder. And in this case, the defendant is saying that a statute that prohibits appellate review of a sentence constitutes cruel and unusual punishment. Of course, there is no constitutional right to appeal your sentence in a criminal case. Appealing of sentences are brought about by statute. And so the statute, Chapter 29 sets forth appellate review of criminal decisions. 295308, I believe it might be C, says that aggravated murder sentences are not reviewable. So death penalty sentences are reviewable, and you can be convicted of multiple crimes, and your sentence could technically be life in prison by the time you have maybe been maxed out on cases, or by the time you have them maxed out and then run consecutively. I mean, there are some cases where people are sentenced to 100 years in prison, and they might be anywhere from 40 to 60 years old. That is essentially life in prison, and yet those sentences are reviewable. You can appeal those to the appellate court. But 295308 says can't appeal a sentence for aggravated murder. That provision provides for life without the possibility of parole, or life with the eligibility for parole, I believe in 15 years, 20, 25, some amounts like that. So Mr. Kinney here is saying that that statute is cruel and unusual punishment and violates the 8th Amendment of the Constitution. What do you think? I guess you'll soon see what we think anyway. Next slide. Write down any of the questions or save any questions that you might have for that provision. Not seeing any questions. Is everyone awake? Okay. Next slide, I'm sorry. So filing of appeals. This we're going to go through kind of quickly because it's really just kind of some technical things and pointers and things for you to look out for. For jurisdictional appeal, for what you need to have, it depends, of course, on the type of appeal you're filing. Jurisdictional appeal, just two things. You need to have your memorandum in support of jurisdiction and notice of appeal. And your MISJ, your memorandum in support of jurisdiction, can't be more than 15 pages. So you can't attach things to it. At the Court of Appeals judgment entry that you appeal from, and your memorandum, that's it. Now, the other side can file a memorandum opposing jurisdiction, but the other side does not have to. And whether the other side does file, the opposite side does file a memorandum in support, does not impact, sure it should not, but it doesn't impact how the court will rule on whether or not to accept the case. It essentially, if it fits our other criteria, is it of great in general interest or public importance? Is it a substantial constitutional questions? Those sort of things. And sometimes the other side wants the court to take the case too. And in some occasions, even though that one party might be a prevailing party, there are times when both parties want the court to take in a case. Also, there can be amici briefs. There can be amicus curiae memorandums in support and jurisdiction filed with the court. So those can be filed to support your position. And there can be amici briefs filed, of course, opposing accepting jurisdiction over a case. Next slide. So for your filing jurisdictional appeals, these are just some technical things. I won't be specific about them. You'll have them for you. And everything that we're talking about here, particularly the technical things, are on our website. All the rules are on our website. All of the provisions I'm talking about here, that some of I've abbreviated. And I do have the website stated, I think, a couple times during the PowerPoint. But everything is pretty well outlined on our web page. It's on our website. The statement that on your jurisdictional, the important part, if you look midway on the slide, the statement that one or more of the following is applicable. And of course, the boilerplate language is the court should accept this jurisdictional appeal because it, one, raises the substantial question. One, it involves a major felony that, it's of great concern for criminal cases across the state. It's one of great general interest or great public interest. It's termination of parental rights. It involves a death penalty post-conviction proceeding. Set forth those things, make it clear. The easier it is for us to see it, the less consternation we have with maybe deciding it, and or you make sure that the significant aspect of the appeal is before us. Next slide. We will kind of go a little bit through this. These, again, are just some technical stuff. Next one. Again, technical, you can read that. And one thing on the signature, your memorandum support jurisdiction must have your signature, and your signature can be included at the end of the 5th page. Don't have 16 pages, because your memorandum of support jurisdiction can only be 15 pages. If your signature flips over to the 16th page, then you have exceeded the page limit, 1, so that 16th page is not considered, and you won't have a signature on it, and so the excuse me, the document hasn't complied with all the rules. And I know that seems technical, but those are the things you have to watch out for. So be sure you see what they look like, and particularly those who might do e-filing, and there might be some displacement of the pages. Next slide, please. Do not, repeat, do not attach things. This is just to get into the door. If you can't cogently state in 15 pages without needing show and tell in there, then it's probably not something we should hear about. So the opportunity for other attachments and transcripts of the record and affidavits, et cetera, will come after your appeal gets accepted and the record is certified from either the appellate court or the trial court. So by all means, don't attach things. Our clerk's office would be glad that I'm saying this. Next slide. Again, some technical stuff. I mean, these things are, and again, they're on our website, and they're things your offices probably knows, or whoever's responsible for getting your pleadings ready and drafted. Just be sure that they pay attention to this. I want to call attention to the very last thing at the bottom, the filing time deadline, 5 o'clock for everybody as of today, for in-person filings at 5 o'clock and e-filing. However, on January 1, the e-filing deadline will go to 11:59 p.m. We recently passed that, and that will be effective January 1. I think I hear some applause coming through the computers. And it makes sense. It's something that I and a couple other justices, on the campaign trail, I said that's one of the things we're going to bring up. Unfortunately, we got that done. So many of you are in court, even in different counties, and although I know you're not doing too many trials right now, oftentimes lawyers are in court till the end of the day, at 4:30, 5 o'clock, and the deadline to file has passed. Now at least we allow you to not go get dinner or maybe get something brief to eat, then work on the brief that you need to submit and get it in again by 11:59. Now, the downfall of that, of course, is you won't have anybody at the court to help you should you get some kind of technical glitch. That's on you, but we still feel that extending the e-filing deadline to almost midnight should still be a help to practitioners. All right, the next one. And there are some common mistakes. I brought out a few of them. We talked about some of them, of course, missing deadline, failing to attaching certain things, exceeding your page limit. Often too, particularly in a complicated case that either might have more than one case number from the trial court, or some ancillary matter. So referring to the wrong judgment entry that comes through. Just be diligent, particularly when time might be of the essence and you're rushing. Next slide. Again, some more common mistakes. You'll have those. You can read those. Next one. Notice everything. No font smaller than 12 point for us. Every justice on the Supreme Court is over 50. So anything smaller than 12. It might not get, even with these. We can go on, continue with those. Okay, so get some final thoughts, and then we'll allow questions. The citation manual is good to know and to use. It helps when all the citation form is the same. We have that, we put it out there, the book is online, you can do that. But one of the most important things substantively, and I like to try to tell attorneys often, is if you haven't done appellate work in the Court of Appeals, but particularly in the Supreme Court, if your case is huge, or if your case is really important, consult a colleague or someone else who has been at the Supreme Court level. Although it is appellate review, it is appellate advocacy, it is slightly different. It is slightly nuanced. And at the Court of Appeals level, I mean, you've got to get 2 of 3 judges to agree with your position. At the Supreme Court, you need 4 of 7. And you know, the more judges you get on it, the better it is. And so there are a lot of eyes on your case. If you can't get anyone who has argued in the Supreme Court, go back and look at some of the arguments we have. Now, we've been virtual since March, but those arguments are still recorded. They're live streamed and they're archived. And so at any time, you can, one, go to our docket from our docket portal from the website. You have access to pleadings of cases with similar issues like yours. And I have to, and some of those briefs and memoranda in support of jurisdiction are excellent. There can be no better tools to use. If you find through your research, Westlaw or Lexis, a case that is on point with a case that you have, and it's a case the Supreme Court has considered, or even, you know, we deny jurisdiction, there's still a memorandum in support of jurisdiction attached and in the docket. And those are public records and you have access to it. And there's no secret password to get through them. And so use those, take advantage of the good work that your colleagues across the state do. And again, listen to oral argument, because again, by the time you get at this level, just like with the United States Supreme Court, most people are lining up their votes based on how they think a judge will decide, either based on his or her decisions on similar issues in the past, whether you think a justice leans to the right or leans to the left, more pro-business, more, you know, anti-business, you know, those sort of things. I'm not saying those are monikers we have, and quite frankly, I think they're very superficial, but they might still matter, and so you've got to get your argument accordingly. And I believe, is that the last slide? Let's see one more time. We've got to thank you there. I've got one question for you before we open it up. So on certified conflict cases, we get those from the Court of Appeals when one district says that its opinion conflicts with a judgment of law from another appellate jurisdiction. If a Court of Appeals makes a decision on a case that is in conflict with the rule of law in a decision that that particular court made on the same issue. Maybe the appellate court in 2020 decided a case that same appellate court decided in 2015, and they conflict. Does that come to us? What happens there? You're right. I'm confident that at least one or more of you said that the appellate court has to have an en banc hearing to resolve its intra-district conflict within itself. Those are also cases that are very interesting and likely to get heard at the Supreme Court level, particularly if it's a divided decision of the court. As some of you already know, or as Randy read in my bio, I sat on the 8th District Court of Appeals before coming to the Supreme Court, and that court is the largest appellate court in the state with 12 judges. And we heard more en banc decisions probably than the appellate district because there's 12 of us. So at any time, there are 4 different panels. You can imagine we conflicted with ourselves. So the response is, as I'm sure some of you shouted out at the screen, an en banc hearing. So thank all of you for your time and attention. I hope you're staying safe. And I'll entertain any questions you have. Going back to Randy.
Thank you so much, Justice Stewart. It's been a good morning. We appreciate your presentation. We don't have a lot of questions at this point, but of course, as we said before, if people have anything, let us know. The one question that did come up earlier is about how we would know people are attending. As we had indicated first thing this morning, we will be sending out a survey which you will attest to the fact that you stayed logged in. We can see who logged in. We actually had quite a few more people than had signed up. So if we don't have your attorney number, just let Kelly know. If we do, you are all set. We will have the materials on the website. And then for tomorrow, please make sure to log in and remember the password is DEC11 as opposed to DEC10. Okay, apparently that's not the password. So Kelly, take a look at her email and she will use the password that she provided. If you have any questions, shoot her a password and we'll do that. I definitely want to thank Frank and Greg, Leslie and Mark, and of course Justice Stewart for today. Tomorrow, we have some very interesting presentations. We're going to start at 8:30 promptly. So we do hope you'll join us. We thank you for today and hope you have a wonderful afternoon. Thank you.